Here we go. Thank you. Hi, chat. How are you guys doing? Sorry, I was trying to set the desktop up and I don't know. I something bad happened and I was trying to fix it. Like there's like little lines all over the screen. Um the monitor, like I mean the desktop didn't get like rough handled anywhere. It sat in the back of the car and then it's like I don't know. I don't know. We've had a sorry. Got a lot of problems. So I don't know what to do. Um I don't know if the tower's fucked. I don't know what I'm gonna do because I got so much shit on there. I hope it's not. I hope it's not. So we'll. I don't know. I guess tomorrow we'll try this live. But nothing was working. So Rip Sean's monitor. Well, I'm worried if like the monitor, but like the tower. I don't know what the hell happened. So I'm hoping it's okay. And like it's just it sucks because like having two monitors, bigger monitors, it's a lot easier to run this stuff on. I know you guys are upset about the sound. I don't know what to do. I don't know what to do to make this all freaking work. So um I don't know if this is a better microphone that's not to the webcam, but uh did you unplug the GPU before packing? Yeah, I did. I don't know what the hell happened. Is there any second the GPU? I don't know. I mean, nothing happened to it. It never got dropped. It always got handled properly. So I don't know what happened. Oh, I'm just got to figure out tonight. Okay, I'll check everything out. I'll check everything out tonight. So can it power on or is it completely dead? No, it turns on. Like it shows Windows running, like the screen's there, and there's just a bunch of little lines, bunch of little white and gray lines all over the place. So I don't know what the hell's going on. Um, so I don't know. I don't know what the deal is, guys. I don't have more time. I kept you guys waiting. I'm freaking out about it, and it's just like I'm getting more aggravated. We just need to start the goddamn show. So toilet paper's gone. Yeah. Yep. So did you forget to bring a watch with you? No. The paper towels are gone. Never forget. They're not paper towels, they're toilet paper. They are toilet paper. They're poop tickets. And Fair Frozen said, had that happen, even a bit of emotion will jiggle things off. Try checking everything. I'll check. I'll check and make sure the graphics card. I'll make sure it's all in there. I don't know. I'll take a look. I'll take a look. So not sure, guys. I'm not sure. It's just it's not. So we'll see. I mean, anyways, big things happened last week on Friday. Um, the biggest one, I guess, we'll start off with is Aaron Spencer. And Aaron Spencer's case got dismissed. And it's the case has been dismissed with prejudice at this point, which is good. And from here, what happened? Well, a bunch of things had happened. And there was a big motion that was filed by Aaron Spencer's team, primarily regarding the loss of evidence. The evidence issues surround the loss of Micheal Fosler. Remember, Micheal Fosler is the pedophile who had been molesting Aaron Spencer's daughter, and Aaron Spencer caught him with his daughter, and then, had the whole police chase and ended up killing Fosler. Well, Fosler had a dash cam, and in that dash cam, there was an active SD card. In that SD card, though, we found some things. We found some issues with the SD card. Primarily, they're gone. They're gone. You might say, well, wait, what is that? Well, literally, the card is missing. We don't know where it's at. And you're like, well, who had it last? Who had it last? Well, it's just gone. It's gone. Yes. So apparently, one of the Arkansas, Attorney General's office investigators had it, and then somebody from the sheriff's department had it, and then they, it's like we're gonna get to all this, but it starts kind of steamrolling from there, and you're like, well, wait, what happened? And you're like, okay, well, we don't have it anymore, and they're like, what do you mean you don't have it anymore? Well, we're to that point now. We're to that point now. We're to the point now of what happened to Aaron Spencer's thing, and it's wait, why is this not? Why is it opening up with that? Well, anyways, I don't know why it's doing that, but anyway, so Aaron Spencer filed under a couple different theories of law to address this. Sorry, guys, everything was trying to set up on the desktop. Sorry. So here we go. Let's get into it. What happened with Aaron Spencer, because this card's missing. And what was on the card? Well, we don't know what was on the card. Kites, if you need help with CMP, I got a spare GPU to test. I don't know what any of that means. I don't know. I'm going to have to mess around with this. If it's fucked or not fucked, I don't know. I'm going to have to play around with it later. So I'll be up tonight trying to just turn the computer on and stuff. So I don't know. I don't know what any of that meant. So I don't know if it's working or not. Like, it doesn't tell me anything. So I apologize. Okay. For $2. Thank you. And then C3 Metal Thingies for 10 subs. And EDW Raptor for 10 more subs. Let's go tonight, chat. We get some Clio Woos here in Florida. That's what we're doing tonight. Chat. Adam says, will Aaron Spencer be compensated? No. Your privilege is a privilege. You get to go free today, Aaron. That's your thing. Also, is this microphone better? I think it's the laptop mic. Trying to switch them up. So, anyways, we're going to keep going here. Let's get to this case and see what happened. And why is none of this loading? Where is... Okay, I hate this. This is... Oh, it's frustrating. I just lost everything. All right. We'll just start all over again. Hallie's tab's open, and after a while, if you have a document open, the tab just like, I don't want to be open anymore. A little frustrating. Oh, there we go. All right, chat. Here we go. So this is Aaron Spencer's motion to dismiss for due process violations. And primarily the due process issue is spoliation of evidence is also another issue here. This is filed by the court. This is the order granting the motions here. So what happened? Well, this is where the bombs start dropping. You can hear me fine? Good. You prefer less echo? There you go. All right. So what did we get here? So they talk about the rules limiting evidence and to enter an order setting aside prior orders and expert witnesses and to enter order relief granting the state's destruction of evidence. Because remember, we're talking about an SD card that just up and disappeared. Isn't it funny how that happens when, the state does it? Well, and all these orders, look at all these orders that were filed and briefs that were done. The court hereby grants the motion to dismiss pursuant to the due process violation of the 5th and 14th Amendments and Article 2, Section 8 of the Arkansas Constitution. So what happened? So they talk about the affidavit for the arrest of Aaron Spencer. And they talk about the facts constituting reasonable cause. So at approximately 1 o'clock in the morning, deputies responded to a call in reference to a missing juvenile. They were advised that missing juvenile had been raped and assaulted by Micheal Fosler in July 2024, and he was driving a white F-150. So they requested the Cabot Police Department send officers to locate the missing juvenile at Fosler's residence. Prior to receiving that, dispatch received a call from the father, identifies Aaron Spencer, saying he had located the man who kidnapped my daughter and his daughter, but the male was dead on the side of the road and that he had no choice. Based! Absolutely based by Aaron Spencer right there. Aaron Spencer is based. Absolutely based. Deputies arrived at the address inside the rural area of Lonoke County, Arkansas, and located Aaron Spencer and Micheal Fosler. Technically, he was in Muerto. Deputies immediately began life-saving measures, but he had succumbed to his injuries. Remember, chat, 15 shots. 15 shots. Deputies took Aaron Spencer into custody and secured the female juvenile away from the scene. Deputies cleared and stored the weapon, a Glock 19 Gen 4. Oh, yeah. I mean, a Gen 4, though. We all can't have Gen 3s. I was hoping it was going to be a Beretta, but I'll take the Glock 19 out and do the Fosler drill. We'll do that one day here at the range. That was found to have been on the person of Aaron Spencer, and blood was on the outside of the weapon. I hope he gets it back with all the flecks of blood on it. What is that stuff resting on there? The blood of a pedophile. Based. Then we get to this guy, Detective R. McCain. He's going to become important in this. I was the first detective on the scene. I observed a white F-350 sitting north at the scene, angled and northbound, with a white F-150 sitting next to a driveway. Think about that, Chad. An F-350 versus an F-150. That's not a competition at all. That's getting forced off the road. The white one had been forced off the road due to skid marks located on both the asphalt. Fosler was lying on his back. He had visible puncture wounds on his chest, abdomen, and his upper arms. Well, gee, why did he get shot in the arms? Because he was probably going like this. I think it's pretty safe to clear, like he was advancing. Upon inspection of the F-150, damage located on the rear, seeing an after impact on another object. During the search, several spent 9mm cases were found on the roadway, driveway, and ditch. Once clearing the scene, myself and Detective Rice interviewed Aaron Spencer, and after being advised of his rights, which he acknowledged in the events that occurred, I mean, yeah, he talked anyway. It's not the best, but okay, it worked out here. Aaron said he woke up by his dog, which was uncommon, went to check on his daughter due to events that occurred earlier. Spencer further explained he looked closer at what he thought was his daughter in bed, and he realized it was a stuffed animal with his daughter's hoodie in it. Aaron stated he became scared and had his wife call 911 to report her missing. He then left and began a search for Fosler and his daughter. And he arrived at the intersection of Highway 236 and Highway 31 North, and he observed the white F-150 turn off, heading toward his residence. What the fuck was going on? Aaron then stated that he was in fear for his daughter's life and continued to, pursue. That's brilliant. Yeah. The Arkansas deputy. Hoo-wee! Hoo-wee! Spencer then stated he was in fear. He explained that when they arrived at the intersection, he hit Fosler's vehicle in the rear, causing it to slide off the highway. He then exited the vehicle with his firearm in hand, based, and ordered Fosler out and lay down in the ditch. Spencer stated he observed his daughter trying to exit the passenger side, but it appeared that Fosler grabbed her and stopped her from getting out. Oh, he thought he loved her. Well, I hope he's enjoying it in hell. Spencer then stated that Fosler then lunged toward him, saying, "Fuck you!" I'm sure like a shrill Baldo maniac. Aaron Spencer stated that he then opened fire, emptying his weapon before jumping on top of him and pistol whipping him. Based! Based. Already, chat, we're going to wear this out tonight.
Was this story based? Yes.
Based. But, Aaron Spencer just coming out there and just... That's my interpretation of what happened there. My interpretation is what happened there. Aaron stated he got his daughter out of the vehicle and returned to his truck where he called 911. Okay. So judicial notice. These are things the court can take notice of that don't require any proof to establish because there are things we can all agree on. Micheal Fosler was charged with 43 sexual-related offenses, with defendant's daughter as an alleged victim. So it wasn't the only one. He was probably touching a lot of little girls. The offense dates are between June 1st, 2024 through July 5th in Lonoke County. There is a fake copy from an unfiled form document under the heading in the Circuit Court of Lonoke County, Arkansas, with pending charges boxes checked and styled pretrial order, showing a bond amount of $50,000 with a box form check stating the defendant shall have no contact either directly or indirectly through any means with any minor with or his or her immediate family or friends. The court takes notice that Fosler did not appear before a district judge for a first appearance hearing. Although the reference above document was in the county circuit, it was signed by a district court judge, was unfiled, and wasn't discovered by defendant's discovery until late 2025. Micheal Fosler's first appearance was on September 6, 2024, when he appeared with counsel, entered in a waiver of arraignment, and pretrial dates are set. Under our legal system, Micheal Fosler was presumed to be innocent. No. To quote great Ethan Ralph, no, he wasn't. Why was he out with a 14-year-old at 1 o'clock in the morning? Why? So applicable case law. And they talk about here things. They cite a case, State v. Clarks. The recent Supreme Court case of that and U.S. Supreme Court cases, within that opinion, control the issue of defendants' alleged due process violations by the state for destruction or loss of material that's potentially exculpatory. The relevant one, guys, we're going to get to the great ones here. Brady versus Maryland. That is an oldie but goodie that we're hitting to, but we're going to get to that you guys probably not heard of too much. California v. Trombetta in Arizona versus Youngblood. Those are two you guys probably haven't heard of, but if you ever deal with spoliation and destroyed evidence, these are two that become important. So, here we go. This is where we start. You guys are going to learn a little bit different case law tonight. The Clarks case reversed the trial court's dismissal of 5 felony counts on a denial of due process claims for law enforcement's failure to preserve body camera evidence, particularly because the Arkansas Supreme Court held it is the defendant's burden of proof to show a due process violation on those grounds. Okay, and yeah, Aaron has to show it. The Brady case recognizes that due process is triggered when the prosecution has suppressed material that's exculpatory. Suppressed material exculpatory evidence, and the defendant has the burden of proving a Brady violation. And exculpatory evidence is evidence that may, it doesn't have to, it's just may and might, tend to exculpate, meaning reduce the defendant's culpability and their liability, whether or not they did it. They say among the U.S. Supreme Court and Arkansas cases, the Clarks case took the opportunity to clarify the standards when the state loses or destroys evidence. So it happens under 4 things that happen. When the state destroys material evidence whose exculpatory value is apparent before destruction. 2, the defendant cannot obtain comparable evidence by any other means, which in the case of this SD card from the dash cam, there's no other way to get that. There's only one. It's one of one in the world. The state also violates due process when it destroys or loses evidence that was potentially useful in the defendant's case, and the government acted bad faith in the destruction of the evidence. And again, the defendant must prove the state violated either or both tests to obtain relief. Guys, you don't have to prove both, but you gotta, you pretty much have to prove both. Either or. Here, the defendant must prove both prongs of either or both tests. So the court addressed the arguably harder prong to satisfy bad faith. Now, this is where we get into some things with the police. Here's the issues. So Lonoke County Sheriff's Office has detailed policies that set out the handling and processing of evidence. The issue here is the dash camera found and a detective on duty in alleged Micheal Fosler's truck. The dash camera mounted on the windshield of the decedent's truck was there and allowed it to record events in the truck, inside the truck, and potentially behind the truck. Yeah. Depending on what type of camera it is and depending on if Micheal Fosler just had a Simple cab, you can see out the back window because it's right there behind your head. And depending on how the truck is bumped and rammed off the road, that can activate your dash cam. So Detective Robbie McCain, remember, this is the same detective from above, removed the dash camera from the windshield without its original position on the truck being a recorded, photographed, or sketched as part of the crime scene. Nor was the dash camera itself photographed or recorded. Remember, chat, when you collect evidence, where did you find it? I found it in the truck. Where in the truck? On the windshield. Oh, here's a picture of where it was. Here's how I found it. Here's how it was orientated. None of that was done. None of that was done. And it's, it's basic stuff. Think about it. If you were finding evidence, you would take care of it. You guys would probably do this. You would do it the right way. You would probably do it the right way. But from here, we don't have that. But what does Lonoke County say? It should not be disturbed until it has been photographed, measurements taken, its position recorded in the crime scene sketch, and entered into an officer's notebook. Detective McCain's actions that morning violated procedure. Yeah, no shit. According to an inspection by Jason Stacey, a retired Hot Springs chief who testified under oath at a pretrial hearing, the dash camera mount was broken when it was recovered from the windshield of the truck, and the dash cam's internal settings were not preserved. Its internal battery was allowed to drain, resulting in a default setting of August 1st, which probably rendered the dash camera useless after that time. And guys, there are standards on how you keep things powered up, how you're supposed to shut them off. You guys have seen these body cams. What do police do? They immediately put phones in airplane mode, or they'll put them in Faraday bags. You do everything you can to preserve the evidence, and electronics like dash cams, you make sure you preserve them the right way, and this wasn't done. So internal memory is probably gone. As for the SD memory card, Detective McCain stated in his affidavit of December 2nd, he noticed the dash camera had a micro SD in it. He removed the SD card out of the dash cam and placed it into an adapter and opened it on his computer. He said he viewed 3 of the videos of 15 minutes and a 4th video less than 15 minutes. So he definitely looked at this. He definitely looked at it. Okay, but how many more were there? How many more were there? He further stated he placed the SD card back into the camera and placed it back into the original manila envelope. Okay, but what was on the videos? What was on the videos? Notice they say that is controverted by expert witness for purpose of the pretrial hearing of Brandon Purchase. What does that mean? This is controverted? That means the judge is looking at Detective McCain saying, you are a liar. You are lying. The judge saying it's controverted, meaning this guy's a liar. According to the expert that was brought in, Detective McCain and Lieutenant Giacomo, the criminal investigation head, that is a very whopping name for Arkansas, really, stated that the practice is not to manipulate electronics or check for SD cards before sending the devices to the Attorney General's Digital Forensics Unit. So we're not doing anything at all correctly. The policy is not to manipulate because doing so takes a chance of wiping data and everything else. Furthermore, Detective McCain was trained not to remove SD cards for the risk of wiping data, and that they don't generally check whether a device contains expanded memory. Finally, Detective McCain said they dislike manipulating any other equipment before it was sent to the AG's office. See, after removing the card from the camera, Detective McCain did not photograph it, record its data size, or mark it as a separate item of evidence. And that's something, guys, you're saying, like, well, if he did it, he's supposed to tag it. Remember, it's like when you're in court and you, like, in a case, something gets presented, and then somebody goes up onto we talked about this before. If I have an exhibit I put up on, like, an easel, a map, and then somebody draws on it, we've now generated an exhibit. This is a new piece of evidence. You pulled the card out. You shouldn't have done that, but now you have. We have to control the card. The chain of custody becomes critical here. And nope, he's like, oh, I pulled it out and put it back in, but the card's gone. So where did it go? Oh. Now, Detective McCain says the actions were taken. It says they violate another thing. All recovered evidence must be immediately and properly marked or labeled to ensure its proper identification at some date. Each piece of evidence must be marked when it is removed from the original position. Evidence will be marked by use of deputies' initials and case number when practical. The date of recovery and everything shall be affixed to the exhibit whenever possible. They talk about the other parts of this evidence preservation. You can further protect it by selecting a container that will guard against contamination. In paper wrapping, placing it in a sealed label with a tag, logging all property in the property section in the reports of the evidence custodian can properly maintain chain of custody. And the next part's a chain of possession. And they say the correct methods used in packing and evidence may be nullified if an officer cannot account for all the persons who have handled, examined, or stored the evidence. Yes, if you can't show me everybody who's touched it, then you don't know who's touched it. Each deputy is responsible for maintaining the chain of custody and protecting the integrity of his or her evidence. Yes. If the evidence leaves the deputy's possession, he should record his notes, who gave it to him, the time and the date, the reason somebody took it, and when and who returned it. None of that was in compliance. Another area of problems were the general request for forensic examination. That form shows the item of evidence, a black silver 1080p camera, was submitted by one of their sergeants and received by the special agents there. Within the large box on it said on-site preview, checked unknown. This item of evidence, presumably for the dash camera, was returned 11 months later. In the detailed evidence forms, it was listed this was sent to the AG's office in 10/14. A check back in on 10/16. This form indicates the acquired position was father's windshield, and this item of evidence was acquired on 10/8/2024 at 4:13 in the morning. So that does mean it's the dash cam. Between these two dates are a series of emails between the prosecutor and defense counsel. The first email is a disclosure from the prosecutor to let her know about a dash cam that was apparently in the decedent's truck that was taken into evidence by the incident, and that the detective took the SD card out, reviewed the files, but all the files showed to be after the incident and just showed blue lights in the background and no other exculpatory evidence. That email said this was all sent to the AG's office, but it had come up missing. Really? That evidence also referenced Detective McCain unplugging the camera. A follow-up email stated there was no internal storage within the camera, and that is a crux of this missing, lost, or destroyed evidence, not preserved by the state. Yes. State's unable to discern when the Attorney General's office informed LCSO the memory card is missing. And notice there's one more discrepancy before moving to the pre-trial hearing transcript. The evidence detail form indicated this dash camera item of evidence was sent on 10/14/24, whereas the Attorney General's form says they received the dash camera on 11/14/24. The state asserts this is a clerical error, but it's a clerical error in the midst of all kinds of shit missing. We found more space dust on this. Oh, wow, there's more evidence. Sorry, bro. I'm going to trust the state crime lab to be a little more correct than the police. But now we're going to get Detective McCain's testimony at the pretrial hearing. Detective McCain didn't photograph the dash camera and did not document its existence. In the incident report, notice it wasn't even known in there. If nobody knew about it, think about that. Think about that. Think about that. Do you think it's a video of the PDF surrendering an error and giving them the sauce anyway? No, because if they had that, they would have used it. I'm sure it showed the guy surrendering or wanting to fight. I don't know. Detective McCain admitted the camera was not logged into evidence, but was stored instead in his personal office rather than the evidence room. And oversight, it wasn't logged into the system and it got missed. Oh, because how many murders do you have, buddy? You're not robbery homicide, but this is the problem. Deputy McCain down in Pig Knuckle, Arkansas. Well, I just have too much going on, Your Honor. I was watching an episode of The Heat of the Night, and I didn't have time. My old woman wanted to watch a show. We just didn't have time. We just didn't have time, boss. The dash camera was not logged into evidence until over a year after it was collected. Detective McCain removed the memory card before logging in evidence and viewed the contents. Detective McCain said this is the only dash camera they've ever seized during an investigation. I find that hard to fucking believe. After viewing the contents, he placed the card back inside the camera, placed the camera in an untaped envelope, and put the envelope in his office cabinet rather than logging in evidence. Pre-trial expert Brandon Purchase noted the SD memory card snapped securely within the dash camera. Their sergeant took the dash camera to examinations. Notice she's going by the Attorney General's dates. She doesn't trust the police department on this. The AG's office did not receive the memory card containing the data from the camera. None of Detective McCain's actions regarding the camera were documented in any database or log. The failure to place a dash camera in evidence resulted in the camera not being logged in the system until they got it back. There's no mention of the dash camera in any discovery or law enforcement documents until it came back and listed the camera as evidence. The memory card and dash camera should have been listed as two entries as separated. They should have. But Aaron Spencer didn't even get to know about that. Think about this. In the Heat of the Night, the movie is greater than the Heat of the Night, the TV show. I like the Heat of the Night, the movie. It's got Rod Steiger and Sidney Poitier. It's a phenomenal movie. Mr. Tibbs, solving the crime case. But the TV show's pretty good too. Are you telling me you didn't like Carol O'Connor in that? TV show's pretty good, especially Bubba. Like all those guys were great. Hold on one second, chat. So we're gonna keep going here, but yes, The Heat of the Night, the movie is great. If you haven't watched it, it's actually I think Sidney. Wait, did Rod Steiger win an Oscar for that? I think he did. It's a 1967 movie. It's actually really good. Yes. It won Best Picture, Best Screenplay, Best Actor for Rod Steiger, who later played Napoleon in Waterloo. Even the theme song won a Grammy. But yes, it did really good. Won 5 Oscars. So. Now, and they say typically they send out electronics to the AG's office for examination. In this case, with the exception of the dash camera, all other items, including memory cards, phones, tablets, were sent without first attempting to view them. Detective McCain did not document assessing the card or what he saw when he did so. As an aside, there's a probability that he didn't see what he said he saw based on the sworn testimony of another guy. That powering off the camera does not delete anything from the card. Ooh. However, the court was not present at that hearing, so no findings can be made. And what's that saying? This judge, remember, the previous judge was the one handling the case before. And she, for some reason, didn't think this would be a problem. I'm sure she wouldn't. But it took them bringing in an honest judge to take care of this. But does that make you think of what happened? Hi, Maddie. How you doing, man? Good to see you. V2 says the Oscars are gay, woke, cringe, and all political. 1967, they weren't. It's actually a very good movie. Making sure I didn't miss anything here. But no, guys, this was some good stuff. There's some actually like important things that happened here. But this court does not believe Detective McCain. Other testimony. Lieutenant Portali stated that McCain's failure to document the removal, the failure to document pulling the card out, the failure to document what he saw, and failure to document its loss all violated policy. Yes. There was other testimony at this hearing that indicated the decedent's truck accessory was still powered up and running the camera when Detective McCain unplugged the dash camera, powered it down, and then a splash screen went off, which was disputed by Brandon Purchase, but the court will not make a credibility finding on that. The court's not believing the cops here. At the same pretrial hearing, the Attorney General forensic examiners found no SD card when she opened the package containing the camera. And there are 6 memory cards found in Fosler's house and 6 memory cards found in his truck. 6 separate memory cards in his fucking truck? What the fuck? What in the name of pedophilia was this guy doing? He's being a pedophile. In light of these deviations of procedures and outright violations of these procedures and practices, and intentional actions of law enforcement in not preserving the memory card has been lost or destroyed. This establishes a pattern of policy and procedure violations and gives the appearance of a cover-up. Yeah, it does. The state argues the violations are mistakes, errors, negligence, and unintentional, not amounting to bad faith. The state further argues the definition of bad faith is limited to the definition set forth in Starks. That case also said citing Trombetta, when law enforcement follow their standard operating procedures, typically shows a lack of bad faith. Conversely, it can be logically argued that failing to follow standard operating procedures is evidence of bad faith. And the defendant has cited cases from other jurisdictions that define bad faith regarding the loss or destruction of evidence. Efforts to conceal the existence of the information, its contents, failing to adhere to rules and professional obligations, deliberately omitting mentioning of evidence or admitting it from reports. It's kind of a big one. Oh, I forgot to put that in there. Fail to subordinate an item to evidence, denying its existence. Fail to timely alert others to destruction or misleading as to the circumstances. And he lied. And while these definitions aren't precedent, they're influential, helpful, and persuasive. The court there finds the defendant has proven bad faith on the part of the state in these particular and unique facts and circumstances. Therefore, the bad faith prong has been satisfied. Okay, well, now we got to move on to, was it potentially useful evidence? So, what do we know? Well, they acknowledge the evidentiary significance of the dash camera. Both Deputy McCrane and Lucas answered yes when asked if they immediately recognized the dash camera as an item of value. The defendants advocated as logical and legitimate the dash camera would provide exculpatory evidence, assuming it was working and operational as it was plugged in at the time it was removed. Yeah, if it wasn't working, it would have been taken away. It would have been replaced. Defendants asserts a working camera would have provided the decedent's custody of Aaron's daughter. His directives to the girl in the truck, yeah, it could have. Defendant's attempt to get to the scene to stop the truck and Fosler's refusal to do so. Fosler's act of fleeing from Aaron with Aaron's daughter in his control. The defendant's efforts to safely maneuver the decedent's truck into a driveway. The decedent's aggressive exit, including language he used when he exited the vehicle. The court further notes the state in its response agrees the dash cam possessed potential exculpatory value and would have been potentially useful for both the defendant and the state. That tells me it sounds like the detective may have confessed to what he saw. That's what it sounds like to me, that he confessed to what he saw. Do you think there's got to be on the Brady list now due to the bad faith finding? Ha! You think a place like that in Hee-Hawville, Arkansas has got a Brady list? Well, Brady list down in rural Arkansas. Dude, like half the places I've been in don't have a Brady list. Even when you catch the cops being sketch. Brady list. Get a fucking load of this guy. Get a fucking load of this guy, Brady List. Come on. Come on. There's no Brady List down there. He's probably going to get a medal. Yeah, judges handed the dude a Manel claim. I think so. And the state gets no qualified immunity for that, yeah. Yeah, guys, and that means Aaron probably has a 1983 claim here against the Lonoke County Sheriff's Office. Tenox is a Brady List. What's that? That's the list of cops who have been found to be discreditable on the stand. And if places that have it, they're supposed to disclose to you. Yeah, this guy's on our Brady List. Normally that means you don't let them do things where they have to testify. But I'm sure this guy's still going to be there. Oh, yeah. No, this guy's going to have a rough rest of his career. And I know you guys sent it to me. 2.0 sent it to me. The video of the cop with the lady with one arm. Well, I'm going to do a video on that. This guy's going to get hounded by defense attorneys for the next 10 years for this. So, yeah, it's a naughty list, but nobody gets, not every place has those. I wonder about who's about to be the Lonoke County Sheriff. Yeah. Yeah, I know that's a thing. Fucking McCain better put in his fucking 2 weeks notice. Spuggun says, which one is Manel? Manel is a 1983 claim where you point out that the city has negligently and basically fostered an environment where police are violating civil rights. When we covered the Patrick Tomlinson stuff, the Milwaukee police didn't do a good job of telling their cops quit breaking into this guy's house. Follow these rules. And they never punished anybody for not following the rules. And in this case, it doesn't sound like McLean was ever disciplined for this either. So it sounds like they created an environment where this was set to happen. And yes, it is against the county itself, which will be funny if the sheriff's suing in the county he is elected to defend. But it'll be funny. But yes, it's deliberate disregarding. It's disgusting here. But let's keep going. Also, Mary, how you doing, man? Hope you're doing well. Based on the evidence of defendant's arguments, the court finds that the defendant has proven this prong, thus satisfying both prongs of the second test. Notice this one's actually quick because it's like, yeah, the state agrees. Well, that's an easy way to do it. The state also violates the due process clause when it destroys or loses evidence that is useful in the defendant's case, and when the government acted in bad faith in the destruction. And the court will address the other tests regarding to prove, one, the exculpatory value is apparent, and two, the defendant can't obtain it anywhere. Well, it's apparent. The defendant addressed this prong in May 21st, their brief. They point out that it's intertwined with prong one of the first test. The second prong of the first test, evidence that is potentially useful, is also related to this prong of exculpatory evidence. The defendant's brief thoroughly and extensively addresses the prong of facts and arguments which the court finds persuasive. The court finds the defendant's met his proof and the value of the dash cam before it was lost or destroyed. And ultimately, yeah, the dash cam would have demonstrated what the defendant would have witnessed and experienced in real time. The video is objective and not altered by perception or bias or self-interest. The video doesn't lie. Don't believe your lying eyes, chat. The defendant asserts he has a Fifth Amendment right not to testify and can't be compelled to testify, so his own testimony cannot satisfy the comparable evidence factor. And that's true. He can't be forced to go up there and talk because the state's inaction in bad faith. As argued by the state in response, the only other eyewitness was the defendant's daughter. However, her testimony may be colored by the stress and trauma of the events of that late night and early morning. The dash cam is the only objective evidence there. And the defendant cites 3 federal court cases. In all cases, video evidence was available, but unfortunately, no video evidence is available in this case. They cite a case, USB Web, where there was video evidence of a traffic stop that showed objective evidence that contradicted the officer's testimony during a field sobriety test that nullified the probable cause charge to the defendant with DUI. In another case, Gasser versus Village of President Perry, the video defeated a police custodial claim of excessive force Based on the video, no reasonable jury could believe Gasser's version of events. And then another case, Payne versus Coleman, the trial court held that when subjective evidence conflicts with the video evidence, we must view the facts in light of the video evidence. And you might say, well, that seems pretty obvious. It is, but the courts have to do that. The courts have to do that. But they didn't. These courts reinforce common sense that competent video evidence is objective and neutral and not subject to biases. These court cases are helpful and persuasive even though they're not precedent for a state court. But they do assist the defendant in meeting his burden. The court therefore finds the defendant has met this prong as in the first test. And they say the remedy. Well, what do you do for all this? Having found due process violations, the court finds the loss of the camera has adversely impaired his ability to defend himself, thus his right to a fair trial. The next issue is that of remedy. The last paragraph of the Clark stated, none of the cases cited mention the appropriate remedy if a due process violation is found. There may be occasions when conduct by the police is so egregious that it warrants dismissal, but those should be outliers. This case itself is already an outlier. The state argues it's an extreme remedy. Therefore, the court acknowledges that dismissal is extraordinary and extreme. However, based on the totality of circumstances and the unique, specific, and particular facts and circumstances of this case, the court finds that conduct by police was so egregious that dismissal in this case is warranted. Therefore, this case is dismissed. It is so ordered by Ralph Wilson Jr., Special Circuit Court Judge. Now, think about this. If this was the old judge, she was probably going to let this all slide. And think about this, chat. We see in these court cases where the judges let these things happen. Oh, it's okay. Harmless error. No big deal. Whatever. No problems. Think about how many times we've seen that. But finally, a judge did the right thing. This judge, in a high-profile case, did like the drastic remedy the law required and delivered justice here. It's based. It's absolutely based. From here, there were some concerns about what it actually meant, though, because what does all this mean? Is it with prejudice? Well, good question. Good thing you asked, Green Caps, because the court even acknowledged, okay, wait, I probably didn't do that right. So what do we have here? We have a June 8th order from the court clarifying things in its order. And it says on June 4th, the court granted an order granting the motion to dismiss. Aaron Spencer's release from all bond obligations and conditions. Upon order of the court, this case is hereby dismissed with prejudice. I assumed it was dismissed with prejudice anyway, but it is officially dismissed with prejudice as of this week. It is dead like Dillinger. And Aaron's done. No, you can't be prosecuted for this again. Based on this stuff here. Now, if Aaron said, fuck yeah, I did it. And, let's say Aaron Spencer came up and, he does a 2020 and it's like, he was in the ditch, pissing his pants, begging me not to kill him, please. And I just went, ba 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 ba. Okay, well then you could be charged with that. But no, as of now, Aaron Spencer's a free man.
Was this story based? Yes.
Absolutely free man. Go past go, collect $200. Yes, absolutely based. Yes, this judge did the right thing for once. And you're like, hell yeah, judge. You did the good thing. You did the deed. And, it's not too common we see that. But, we finally did. We finally did. And you know what? We'll take it. We'll take it tonight, chat. We'll take it. And it's just, it's interesting how this works here, okay? It's interesting how this goes. So congratulations to Aaron Spencer and his family. Derek says, did the PDF know the daughter or was it a random? There must have been some affiliation or knowledge because generally speaking, you're the victim of a crime. It's somebody you usually know. Especially in the case of, murders and sex assault, it's generally someone the child knows. And I don't know what relationship he had to her, but yeah, he probably knew her. and had some relationship with her. Yes, and he's on track to become sheriff. Yes, he's probably going to win in a landslide. So, Detective McCain, have fun working at Hardee's, buddy. Because ain't nobody hiring you after this. But Derek for $1.99 says, thank you. Thank you. Still will never be as cool as Gary Pluchet. No, this is up there. This is up there. This gave Gary Pluchet a run for the money. This gives Gary a run for his money. And I want to make sure, did I get to all these other... Yeah, I covered all these other super chats. C3DDW, yes, thank you guys. Just making sure I didn't miss anything here before we move on. Cain Velasquez had to serve time. Cain Velasquez shot the wrong people. Cain Velasquez shot like the other people in the car, and that guy had not. I don't know if that guy's even. What's happened with that guy's case? I think that guy's case is still going. So, but yeah, Cain Velasquez didn't do it the right way. So, looks like it was already happened. I don't know. I'm trying to find. I didn't see anything on it yet for Cain Velasquez, but he didn't do it right. I know Cain Velasquez is out, but he went to prison for all this. Spencer's a close second, but Gary Pluchet is still way cooler. Yeah. Gary Pluchet is the original Wendy No Scope. Well, that too. And yes, and that guy wasn't with Kane's kid when it happened. I know. Yeah. Let's see here. So, Mario's saying, so, Sean, I've never practiced in an elected jurisdiction, okay? I know what they do to appointed judges here if the judge is too based. What may they do to a judge, say, in Ohio? I imagine the police unit at the polls. Well, I mean, it's a rural county. The sheriff's department's not going to be that big. So people in that county are going to vote for him. I mean, if you're based, the people love you. This judge, though, the judge who was originally on the case, the Supreme Court spanked twice. She is retired. So there's going to be a new judge anyway. But yeah, having elected judges, I support. I want that to keep happening. Like Ohio did it, and it was based in Ohio. Judges, they made sure the people liked them. So yeah, no, people like base judges in Ohio. And even Kane only got 7 years, which is light, and he didn't even serve the whole thing. Been there, done that, says Bricks and Minifix stole my toilet paper. Yeah. Kane just got out recently. But this guy's going to be seen as saving the hero. So. DK is saying Spencer's daughter was Foster's victim. Yeah, we all agree with that. His charges that were pending and now closed, I believe, were the entire reason he was looking for. Of course he did. He knew his daughter was a victim, and he knew this guy was preying on her and had preyed on her and, was grooming her. I'm sure he'd been warned about all of that. So, yeah, that's why he went looking. That's we'll see how that works. Luke says Murdaugh's new attorney just got reelected. She was a defense attorney for 25 years, which is based. Cool. Maybe she knows Alec Murdaugh. That might be the only issue. I said, though, chat, on the way down I-95, Walterboro, South Carolina, where Colton County is, it's like the courthouse is like 5 minutes away from the highway. So on Saturday morning it's 7 o'clock in the morning, sleepy South Carolina, I got to go see the Colton County Courthouse, and I put pictures up on Locals of it. It's a cute little square in older town there. So, yeah. Kel says, and he was technically kidnapping her. Well, who knows what he was doing? He just shouldn't have had her with him. And it's reasonable to believe that guy was going to cause her harm. Yes, because Judge Newman's retiring now. Well, Judge Newman sucked. And I think he would, I think he should have been recused at this point anyway, because he made so many horrible rulings. She was in the car with him, wasn't she? Yeah. Yep. Mm-hmm. Yep. All right, guys. So, yeah, good news for Aaron Spencer. Good news for Aaron Spencer at this point. And we are now moving on to the case of Mickey Stines. Guys, the sheriff in Lecter County, Kentucky. Captain Dog says the Gump made his own Kiwi Firms. You joining, Bish? I'm not sure, Captain Dog. Maybe I will. Yes, he recused himself from the Becky stuff. Well, he should have, because he let that happen. He let that happen. But thank you, Captain Dog, for $5. So now we're moving on to Mickey Stines. Guys, remember, he is the sheriff in Lecter County, Kentucky. He walked in to the judge's chambers. And remember, we watched the video from the preliminary hearing. And he's sitting there with the judge talking. He gets up, pulls out his service weapon, and thump, 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 right into the judge. And when the judge is hiding under his desk, Mickey Stines crouches under the desk. He goes, "Oh, there you are. I see you." Bop, bop, bop. And then, gets up and walks out the door and surrenders. So, yeah, here we go. This is a case that, guys, remember, this Kentucky case has so many working parts to it, and so much of it's weird. There's a whole issue of the deputies being involved in this, civil rights case because they were sexually assaulting women and abusing them. There's all kinds of things we need to look at in this Kentucky case. There's all kinds of weird stuff. You're like, this seems like it's an episode of Justified. And it is, because we've discussed it before, guys. Lecter County, Kentucky is way down in the holler. It's down in coal country. If you guys don't know where we're talking about, it's, out here in Kentucky, and it's out there. It's out there in Kentucky, and not too far away from there, guys. In Kentucky is this place here, Harlan, Kentucky. Yes, where Justified is situated. This is out. I mean, this is cities in the valleys. That's where it is. It is funny. The name of the head town is Whitesburg. And you guys can actually see, I think the county courthouse is somewhere around here. I think I got it right. Yep, there you go. Lecter County Courthouse. That's where Mickey Stines came in and murdered the judge in his courtroom. Oh, you guys can't see. Damn it. It's Whitesburg or Whitesville. Yeah. So anyways, here's the Lecter County Courthouse. And if you guys have never seen where we're talking about, we are down in the holler of Kentucky. It is down in the holler of Kentucky. This is right down next to Harlan County, Kentucky. If you guys ever watched Justified, this is where they're talking about down here. This is all along the Virginian, this is the Appalachian Mountains, guys. Look at these. Look at these mountains that are just running through here. I mean, you got these big old bluffs and look at that. Look at that mountain back. Just run that spine running through this area. It's rough. It's a rough country. Rough country for rough people, man. Now, we don't know what's going on there. We've watched Mickey Stines, the body cam video, where Mickey Stines is sitting there just freaking out, thinking everybody's going to kill him. And then when he's getting transported to the neighboring county jail, he kept on thinking people were going to kill him and dump him in the woods. Remember, Mickey Stines has kind of lost his mind here. He's already been submitted to psychiatric evaluation once already. And I don't believe that, we're going to get to some stuff here, some information on it. And the prosecutors are asking for a second mental health evaluation. But we're going to get to some stuff that was involved in this here. We're going to get to, we're going to watch this because there's a lot going on here. And we're going to get to this because it's kind of interesting. It's kind of interesting what happened here. There are some parts where things were dropping out, but we're going to skip around because this is kind of interesting what happened in Mickey Stines' case here. For some reason, I can't get the. For some reason, chat, there is no closed captioning. Let me see your chat. Oh, we do have closed captioning. We'll have to use Long Crime. Sorry, Core TV. Why is this all jacked up? All right, here we go. Here we go.
All right. Morning, ladies and gentlemen. We're here in regards to Commonwealth versus Sean Mickey Stines, 24 CR 204.
Guys, I'm ignoring you because I only have one screen. The laptop's the only thing I have open. So, yes, that's all I've got. And remember, this happened in 2024. Remember, we're like almost 2 years into this one.
Mr. Steele, if you would identify the Commonwealth and who's here on behalf of the
Judge, I would. Defense counsel is not here in order to apply.
All right, let's get them out here, please.
In the meantime, Your Honor, Jackie Steele, Assistant Commonwealth Attorney, 27th Circuit Special Prosecutor's Office.
Francie Dowell, Assistant Attorney General, Special Prosecutor on behalf of the Commonwealth.
All right, thank you.
I represent Kimberly Mullins as Administratrix of the estate of Kevin Mullins, as well as personally introduce. Thank you very much. I'm on you.
Sure. Jeremy Bartley on behalf of Mr. Stines, and also co-counsel Ms. Kerry Bartley, as well as co-counsel Mr. Jimmy Cox. Your Honor, there's members of my staff that are intended to seat in the gallery and not otherwise at the table.
All right,
Can we seat, Your Honor?
please.
Thank you.
All right.
Well, why does he walk like that? Because it's 1.5 times speed, but also, there's not a whole lot he could do because he's in chains. I'm sure that's the most stable way he can walk without feeling like he's going to fall. I've had clients before, like, when you're walking in leg irons, it's a pain in the ass. They'll tell you that. And, he's not the first person to have to experience that. I'm sure he recognizes that from his own, dealing with inmates about this. So, and I'm trying to find, never mind, Chad. I guess I'll deal with that later.
Since we last met, we've got some motions that are still outstanding. We want to try to address some of these and start looking at heading towards hopefully getting this matter set for trial. First, there's a pending motion for a hearing pursuant to KRS 532.135 to exclude the death penalty at trial. The Commonwealth has filed no notice of aggravated circumstances up to this point. My understanding, after briefly speaking with the parties in chambers, is that we're going to hold that motion in advance, pending the resolution of any other potential evaluations, and then if the Commonwealth files notice, readdress that. Is that correct, Mr. Bartley?
That's correct, Your Honor, with the caveat we discussed that obviously it would be in ample time so that it wouldn't affect trial strategy.
Absolutely.
Or if there's any additional experts as a result, such as mitigation.
Absolutely. And that'll be set pursuant to the rules. Next, the Commonwealth's given notice regarding a criminal responsibility examination. Mr. Steele, do you want to address that?
Your Honor, Mr. address that issue.
Your Honor, the Commonwealth, as the court noted, has filed a notice requesting a second mental health evaluation to be conducted by a private expert retained by the Commonwealth, Your Honor. It's our position that the Commonwealth is entitled to that. The defendant has filed notice pursuant to Rules of Criminal Procedure 8.07 subsections 1B and 2B. And accordingly, the Commonwealth is entitled to rebut any defense related to insanity or any evidence going to issues of guilt or punishment related to mental disease or defect. So it's the Commonwealth's position that we are entitled to a second evaluation. We're not requesting funds from the court, Your Honor.
Now, why are they asking? Remember, they want a second evaluation. They want because they got an evaluation done. They want another one. You know what that's key? You know what that's code for? Well, Judge, he didn't say the shrink thinks he's crazy, and we don't agree, and we want a different shrink to tell us. We want a second opinion from another expert of ours. Which that's not a strong sign. Like, that's not good when you're already like, well, Judge, we need a new opinion. Whoops-a-doodle. Whoops-a-doodle.
For that to be done by our private expert and for Mr. Stines to submit to that evaluation, Your Honor.
No, this is not a white.
I've read the pleadings in regards to that. Mr. Martin?
Mr. Trump, the criminal rules, I think, are pretty clear that, in fact, we have to give notice in terms of our intent.
Some of you guys are saying, why is it a broom closet? I mean, guys, this is rural America. Like, most counties don't have really nice courthouses. A lot of courthouses are run down and grungy and kind of ghetto. Also, this is a situation where, like, this room's set up all different because there's a lot of people in attendance. There's press. They're trying to organize it, but this is kind of like, go to a lot of places. This is not uncommon. I know you guys think like everything looks beautiful and clean, but that's not the world, man. The world is far, far different.
To introduce the defense of insanity. I hate that nomenclature, but it still persists, so I will use that for purposes of today's hearing. However, we've given that notice. We gave that almost as soon as we got into the case. And we identified Dr. Drogan as our intended expert. At this point, he's not completed, and we'll comply with the rules in terms of doing so. But the rules of criminal procedure that were cited.
Note, and guys, see, this just reinforces it. They have an expert. He hasn't even finished yet. So the state's doing this because they're this is further proof. The state's own expert has said, like, yeah, I think this guy's crazy. And they're like, no, take it back. Take that back. And he's like, but no, he's crazy.
In the notice, I believe are 807. And under that rule, Your Honor, I agree that they are entitled to have Mr. Stines evaluated. And that's why they filed the first notice and they asked for the court to send KCPC. They could have gotten any expert they want at the beginning. I mean, like they said, they've got the money. They can send them wherever they want to go. KCPC is the Commonwealth's, as they've always made very clear, that is their facility. And they availed themselves of that facility. And he waived his Fifth Amendment right as to an examination. It's a quid pro quo. If you put mental health at issue, then I believe that the Commonwealth has a right to have him examined. And he's done it. And I look in reference, Your Honor, to KRS 504, the section cited in the civil rule as well as in RCR, it's 807, Your Honor. It says that they're entitled to an evaluation. And I believe under the rules of statutory interpretation, the first thing you look at is plain language. To me, "and" signifies, and 504 is adopted by reference into the rule that's cited for the notice, Your Honor. And I believe that "and" in its ordinary meaning means singular. And I think the concern is multiple. First of all, if you look at the case that I cited there, it is Benjamin v. Commonwealth, 266 Southwest 3rd, 775. And in that case, they were looking at a defense request for another evaluation. And they said, basically, if you don't like the result, that's tough. And it's an even playing field I would urge the court to hold here now. Again, if you file notice of insanity, I think there's a limited waiver of your Fifth Amendment rights, but the cases make it very clear it's limited. It's limited in scope, and the statutes address what should and should not be brought in. But the remedy, if he were not to have complied with the first examination, would have been that the court could do anything up into striking his entire defense. But in this instance, Your Honor, we willingly, readily presented him to their expert. That was their expert that they asked him to see. And now what they're asking the court to do is make him go to another. Now, what I suggested in my response was that they could very well, do I believe they can hire another expert and pay them to come in and testify? Yes. I don't think there's anything I can do to stop that. It's the evaluation that I think is the invasive part, Your Honor, that would subject him to get another waiver as Fifth Amendment. We are now 2 years out. You know, the first evaluation will be much more relevant. But if they want to get there and get another opinion and have somebody come in and say, Drogan and Dr. Allen, there's reasons not to believe that testimony, I can't refer to a judge with that testimony that the court's aware of, then I think they can. And they can get there by simply.
Notice he can't talk about it because they've been told not to talk about it. So notice he's kind of like, Judge, you know what I'm talking about, but I still have to make a record. And I agree. They say, no, you already got your witness. You already got your expert. And notice, you know why the defense is saying that? Because that expert agrees with them. They are really leaning on the fact of, Judge, well, they already had their one. That's all they should get. And it's a good argument.
Having them review the procedures by KCPC, they have all the data.
Hi, Karen.
They have all the data that is there, and they can provide that to an expert. He can look at that, and he can opine that the previous opinion is incorrect or impeach it, Judge. I'm trying very hard not to breach the reference room. But I think that's it. In the civil context, there has to be, you're looking at, is there something flawed in this examination? I mean, I think if their motion said, when we send KCPC, they rushed and did it, and it was incomplete, it was this and that, they've had the evaluation, and we agreed that they could share that with whoever they potentially want to look at it. Then I would say today, if there was some evidence they could put on to the court that this was flawed, of course, we would cross that and ask to subject it to proof. But I believe that's what they should have to do, rather than just have him, again, waive his Fifth Amendment right, go to a state expert again. He was compelled to do it from the jail twice. He was compelled to do it at KCPC, Your Honor. And I think that, my question also becomes is, where does that stop? I mean, at some point, how many examinations do we send him to? If this expert, whoever it may be, were to agree with both our expert and Dr. Allen from KCPC, do we get another one? And I think that's exactly why the courts have said that the waiver of the Fifth Amendment in this context should be limited, Your Honor. And I would ask the court to find that he did his part. He understood.
And guys, what he's saying here is, well, that means we get to have another one, Judge. And the judge is like, well, I don't know about that. But he's saying, like, look, remember, you got to be fair about this, Your Honor. And he says, this guy, Mickey Stines already gave his Fifth Amendment right. And if you guys don't know what he's talking about, when you're claiming insanity, you have to waive basically everything to go talk to the shrink. And you have to tell them what happened. Tell them everything. And Mickey Stines has likely spilled the beans on everything. And he's like, look, we already did our part. He did his part. They're just upset this hasn't worked out for them. So yes, this is just furthermore proof stating that the prosecutor's own witness is saying, yeah, this guy was probably off his fucking rocker when he did it.
Quid pro quo. We discussed that on the front end. But what we didn't discuss was a quid pro double quo. And so I'm asking the court they can still get their expert to rebut. I understand there are cases that talk about they get an opportunity to rebut it, but there's nothing that should compel him to once again waive the Fifth Amendment right and go see an expert government mandate, Your Honor. If they can get to the same point without compromising that yet again, Your Honor.
All right, Ms. Allen.
Yes, Your Honor. The Commonwealth's position is that it's clear here, there is no statute, rule of criminal procedure, or case law that would serve as precedence for this court saying that the Commonwealth is limited to a single evaluation of the defendant as to criminal responsibility. There is nothing out there that says that. Instead, the Commonwealth has the burden of rebutting these defenses that the defendant has indicated he intends to present. The Commonwealth's position is that the reliance on the Benjamin versus Commonwealth case is completely misplaced. That was a very different situation. In Benjamin, there was a defendant who was asserting both competency issues as well as criminal responsibility. In that case, an evaluation had already been conducted. The defendant had not, until the day that trial began, articulated specific reasons for a request for funds for an additional evaluation. At that time, the court said, no, your request isn't timely, it's not necessary. And then an appellate court in reviewing that said, due process is not violated, Your Honor. This is markedly different. We're not here asking the court for funds. We're certainly not requesting a second evaluation the day that trial begins. We don't even have a trial date at this point, Your Honor. So Commonwealth feels that our request is valid and that their second evaluation should be conducted of the defendant. Additionally, the experts at KCPC, I believe the defense has referred to as the state's expert. Well, Your Honor, if the Commonwealth is not conceding that the defense can call an expert from KCPC who evaluated the defendant at trial as their expert, but if they intend to do so, then certainly that expert would not serve as the Commonwealth's expert, and therefore we would be entitled to obtain a private expert to evaluate the defendant in this case. As far as any waiver of Fifth Amendment concerns, that is explicitly addressed in the rules of criminal procedure.
And Mario, you're bringing up good points here. Yes, they've made the defense made very good arguments. The problem for the state here is, well, they're saying, well, it's not like, we're not asking for money. That's irrelevant because they have infinite money. The prosecutors have like an unlimited checkbook. If it was the defense, yeah, they'd have to come with their hat in hand and say, please, judge, can we have more money? And that's where people get screwed. So I think it's very disingenuous for the state to do that.
Specifically under 8.06 and 8.07, it says that any statements made by the defendant in the course of these examinations cannot be used against the defendant unless they choose to use those examinations and evaluations to their benefit. So that is addressed directly in the statute. That argument is completely without merit. So we would ask that the Commonwealth be allowed to have their private expert conduct an evaluation of the defendant.
Right. Ms. Barton,
Yes, sure. That's completely the inverse. I agree. There's nothing out there that says they can't, but there's nothing out there that says they can't. And so my point is this, Judge. I mean, so it should be limited to the intention of the rule. The intention of the rule is to give a fair trial. He waived that right. It should be limited, Your Honor, in terms of whether the statements are privileged. That blanket prohibition of the statute is riddled with exceptions. And I'll be very surprised. I'll be extremely shocked if we get to a trial and there are not statements from any of the examinations that come in. It's riddled with exclusions, Your Honor. I ask the court not compel Mr. Stines to, once again, judge, produce evidence that is potentially used against him, Your Honor. Again, he can accomplish both goals by letting them have the prior evaluation, the raw data from that examination, and they can still have someone to rebut them. As far as whose witness it is, they asked the court order he see their expert. That was the first notice, and they said their expert was going to be a KCPC. Now they're asking for an independent expert. They'll both call him expert. The fact that I may call them is irrelevant. I mean, they weren't the courts. I didn't ask for it. So obviously it's their witness, Your Honor. So regardless of who calls them or whatever that may be, we didn't ask to see Dr. Allen, but we do want to hear what he has to say, Your Honor.
all right. Ms. Dahl, if the court does order another evaluation pursuant to the Commonwealth's request, what kind of timeline are we looking at?
Your Honor, we don't foresee our expert he's located out of state in Indiana, but fairly nearby.
Okay.
Of course, there would be travel time and we would accommodate his schedule, but we're not expecting any significant delay, Your Honor.
Okay.
Here, if I may,
Sure.
in terms of if the court does permit, the second
Sure.
expert, Your Honor, then what we're asking is that, once again, Dr. Drogan be permitted the
Absolutely.
original expert, Your Honor. I think it's pretty prudent, and it's not without precedent, actually, with Dr. Allen, that the KCPC doctor be there as well, because if they're going to rebut and be critical of what he did, Your Honor, then I think it is only fair that we should be able to have him observe so that he can respond to the criticisms that they place on the KCPC exam.
Okay. All right.
Your Honor, if I may, the Commonwealth does not have any objection to Dr. Drogan appearing. We would have an objection to Dr. Allen.
If I do order it, I would have obviously no issue with Dr. Drogan being present. I am going to have to look at whether or not Dr. Allen being present would be appropriate in regards to, I'm not making a ruling yet in regards to another evaluation, but I do think the court inherently under RCR 807(1)(b) has the authority to order the second evaluation, but I want to review the pleadings and I will get an order out to the parties shortly in regards to that, because I do want, timing wise, if this is going to be done, to get that moving. So next issue before the court.
Your Honor, can I have one more thing, Your Honor? It shows that if the court does in fact order that examination, then I believe that we're entitled to discovery as to fees paid, and as well as ours as well. I just want to make sure we get that discovery as well.
That'd be no problem at all.
Thank you.
All right. Next, let's go ahead and, Mr. Bartley, you've got pending bond motion.
Your Honor, I'd ask that Ms. Bartley take that issue with court.
Ms. Bartley, go ahead.
Yes, Your Honor. Carrie Bartley on behalf of Mr. Stines Judge, the court has issued an order basically granting us the evidentiary hearing that we requested. It's the Commonwealth's burden to put on proof that the defendant's guilt is proof is evident, or the presumption is great of his guilt of a capital offense. We don't believe that they would be able to do that. Cases under Markham v. Broughton say that essentially where conflicting evidence creates a plausible basis for self-protection, which is.
Now, here's the thing we're getting at. They're talking about here. Well, then our shrink has the right to come watch that shrink. And the judge is like, okay, yeah, I'm not going to make, like, we're not doing this to turn into a circus. He's like, yeah, fine, we'll watch each other. They'll look at each other and watch what's going on here. So the insanity issues there has not been resolved, kind of. The death penalty issue has not been resolved. Now, this is another one about the issues about self-defense here.
Not necessarily what we have here, or a reduction out of the capital range if the Commonwealth can't meet that burden. And so, Judge, what we would ask is just for the court to hear the Commonwealth's proof, and then if necessary, then we have some great proof that we'd like to sit on as well.
All right.
Did we discuss this previously in Commonwealth District proceed? We're going to submit to court the recording of the shooting that day.
Okay.
It was played, it was introduced.
It's part of the record.
It's part of the record, but we're going to submit it to you for your consideration.
And Your Honor, we would object to that. I believe it's the Commonwealth has to put that on. The rules of evidence apply. The court has rules of evidence apply. We don't think the Commonwealth can lay a foundation for that video today. I don't think they have a witness to testify to that today. And so I don't think that it's appropriate for the court to take it into consideration today if they can't put on any evidence as to.
All right, no objection to the rules. All right.
If I may just say on that issue, I'll be very brief. This was introduced in the preliminary hearing. Foundation was laid. Same counsel was present during that, and no objection to anything.
And Your Honor, at that point, if I may, the rules of evidence do not apply in the preliminary hearing. The rules of evidence do apply today under Young, the Young case. Judge. Court cited that in its own order. And so I would, again, vehemently object for record to this being introduced without any foundation being laid at this particular hearing where the rules of evidence do apply. And, Judge, I just don't think it's appropriate. I think that, it sort of flies in the face of applying the rules of evidence, or for that being the court's ruling, that those rules apply, Judge, if we allow the Commonwealth to put in proof without having any testimony to that effect and without any witness being here to be subject to cross-examination as to that issue.
Well,
Judge, under Rule 1101, applicability of rules, it says, subsection B, rules and applicable rules other than with respect to privileges do not apply in the following instances. Number 5, miscellaneous proceedings, without reading all those. It says, and proceeds with respect to release on bail or otherwise.
Yes, Your Honor, and again, I can reference to the court's bond order where the court specifically references to the Young case, Judge, that says that the subject to the rules of evidence, Young v. Russell, upon request for bail, the defendant may testify, call witnesses, etc. So the rules of evidence absolutely apply. It's in the Young case. It's black letter law, Judge.
all right, the court's going to overrule the objection. The facts surrounding September 19th, 2024, which is the basis of this action, there is information in the record previously which transfers from the district court case pursuant to the indictment. I do believe that it would be appropriate for the court's consideration. So anything else in regards to anything else you want to do on bond?
Yes, Judge, I have a witness if I may.
Absolutely.
Defense will call Ms. Sherry Stines.
All right, this time,
And Judge, if it's okay, I'd like to say at council table, I think that there's an issue with the podium that
that'd be fine.
kind of goes up and down.
All right. Randy, you stay right at the podium. All right, if you will raise your right hand and be sworn. Do you swear from the testimony you give be the truth, whole truth, nothing but the truth?
I do.
All right, ma'am, if you would state and spell your name for the record.
Sherry Stines. SHERRISTINES.
All right, Ms. Bartley, may I ask?
Yes, Your Honor. Ms. Stines, again, Sherry, just tell us where you're from, where you live.
I'm from Neon, Kentucky.
Okay, is that in Letcher County?
Yes.
Right. Do you know Sean Mickey Stines?
Yes.
What do you call him?
I call him Bubby.
Bubby? Okay.
Yes. He's biologically.
Now, chat, what are they doing here? Well, they're showing that Mickey may have been acting a little crazy during all of this. And one of you guys asked a question here I'm going to get to. Libby says, just wondering why he's being crazy now, but not before the shooting. Weren't there signs before? I mean, here's the problem, though. I mean, how many people do you see out there? They act a little weird. They might be like, you don't know until you don't know. And we have a general interest in not going after people like that. So that's why. But it's a good question. Good question. And then B Jam in 2000 for $5 says, Sean, I just got back from Beale Street pub crawl down in Memphis. We'll have fun down there. Should go to West Memphis. Go find out where Ethan Ralph lived. Drank too much booze, listened to great music, and too much barbecue was eaten. Woohoo! Well, eating barbecue sounds good tonight, so I hope you enjoy it. We had a fun time. Let's keep going, though.
My nephew, but my mother and father raised him.
Well, that was my next question. What's your relationship to him? So you're his aunt, is
Yes.
that correct?
Yes,
All right. Now, how close of a relationship do you have with Mickey now?
very close.
And has it always been close?
Yes.
How much older than Mickey are you?
I'm 62. He's getting ready to be 45.
Did you ever live with Mickey?
He's
Yes.
40.
It's okay with you if I call him Mickey. I know you call him Bubby.
Yeah.
Damn, he's 45? Jesus! God, it's a rougher 45 than I'm probably going to look at 45. God damn. Man, he's reaped. Just the GPU starting to sag since Sean leaves it running. Monitor, cable, GPU are bored. Yeah, I don't know. We'll see. Yeah, so this is Mickey Stein's aunt. His aunt. He was raised by his grandparents, though. It sounds like. So there we go.
I
Oh,
don't think we're that
Mickey,
close
yeah.
yet, so he may not like that.
They call him Buzz.
Ask you about the date September 8th.
So not only is his nickname's Mickey, but he's also got another, like, that's how you know you're dealing with some, when you're out in the country, when people have multiple nicknames. Oh.
18th of 2024. Do you recall the events of that day?
Yes, it's the day he stayed all night with me.
Okay. And you said that's the day he stayed all night with you. So you saw Mickey that day, is that
Yes.
right?
Yes.
Okay. And about what time that day did you see Mickey?
It was late in the day when he came by the house. It wasn't dark, but it was later in the day.
Okay. And when he showed up to your house, did you know he was going to stay the night with you?
Yes, he told.
Was it common for Mickey to spend the night with you?
No.
Why was he going to stay the night with you that night?
I think it was going to be just to let his wife and daughter rest, for he had been such a nervous wreck and went to sleep.
Okay.
Yeah.
So you said he was going to let his wife and daughter rest. Now tell me, why couldn't they rest?
Because he couldn't sleep and he was wiping the floors, and I guess he was aggravating them.
Okay. Now, did you talk to his wife or his daughter about that at all?
No, not that night. He was at the house, so I didn't. I tried not to get in that.
When he came to your house, had he called you before and said, I'm coming over?
I can't remember if he called and said he was coming or not, but he knew he could come anytime he wanted. It's like his second home.
Okay, so you said he came by later that evening.
Yeah.
And when he came by, did he bring anything with him?
He brought a bag, and in it he had those little tuna creations, and it turned out it was like melatonin gummies and some over-the-counter Benadryl.
And did he have anything to say about why he had Benadryl?
The Hat Man, chat. The Hat Man made him kill. Mickey Stein saw the Hat Man. He thought the judge was the Hat Man. You guys don't know what that is. Allegedly, if you take a shitload of Benadryl, you can trip on it, and you see what's called, people refer to as the Hat Man.
Or melatonin gummies?
Well, he hadn't been sleeping, and it's like he hadn't slept in 7 days and nights. And he had went
Hey,
to the
not that
doctor,
Hat Man.
and
No.
they had told him to take the Benadryl and the melatonin to help him rest.
When?
No, guys, not that Hat Man. The Hat Man is it's a hallucination of people. Because it's kind of like the walrus for it's like the Ambien walrus. But no, like the Hat Man, like people would see like fucking Hat Man. Like people see shit like this, they hallucinate like this thing, like a Hat Man. Yeah, it's like a sleep demon, yeah. Yeah, double dipping on the sleep meds. Yeah, it's like you see a scary guy. So cuckoo cachoo. Yes, exactly. Yeah, melatonin doesn't make you go crazy, but when you take a bunch of Benadryl, it'll cause you to hallucinate. So let's keep going.
I'm assuming it was that day or the day before. It was very close.
So he had gone pretty close in time to when
Yeah,
you don't know for sure the day.
yeah.
Okay. And the doctor recommended to him to take melatonin and Benadryl to
Right.
try to get some sleep.
Over the
It
counter.
knocked a lot of people out.
When he got to your house, what did y'all do first?
And we just basically sit around, watch TV. I went in and I fixed us a little bit of supper. We ate. He didn't eat a lot.
What did you make?
Pork chops, like green beans,
No,
potatoes.
I'm object this time. I don't understand the relevance as to what we're here for in a bond in regards to my question.
I think it shows that she remembers that night very well, and it's not just her making shit up.
I'm going to overrule the objection that as counsel.
Yes, sir. So Mickey got to your house, you ate some dinner, and then what did you do? What happened?
Just sit around for a minute. He was real fidgety, walking from one door to the next. It kept getting later, and I take oxygen at night. So I sat in my recliner at night and take my oxygen. So I give him a bed in my house. I have an extra bedroom. Told him to go lay down. He goes in, he lays down for a few minutes, and then before I know it, he's right back in the living room with me, and he's carrying a pillow. And I said, "Baby, can't you sleep?" No, I just can't. And he would take like melatonin and Benadryl, sit there, keep his phone in his hand. And he was watching his security cameras, walking around his house.
So he was watching the security cameras at his house?
Around his house, yeah.
At his house, okay. And you said, let me go back to the melatonin and Benadryl. So he's taking melatonin and Benadryl. Did you take that at the same time?
Yes.
Do you know what kind of Benadryl or melatonin it was? How many milligrams, anything like that?
I don't know, but I've still got them at home in the bag he had them in.
Okay. So about how many, if you had to guess, or if you know, don't guess, if you know, how many melatonin, how many Benadryl did Mickey take that night?
I'd say about 3 to 4 Benadryl and about the same with the melatonin gummies.
And did those seem to have any effect on him at all?
No,
And so did he sleep?
no.
You said he was on his phone looking at the security cameras,
Mhm.
and he was looking at the area around his house.
Yes.
Did he have concerns about what was going on around his house?
Oh, yeah, he was paranoid. He thought somebody was going to be around his house and, like, I guess do something, bother something.
What was he concerned about in terms of someone being at his house?
He was worried about Lila and Caroline, his wife and daughter.
He's worried about his wife and daughter.
Yeah.
Did you say anything at all? Did you get any indication of why he would be worried about his wife and daughter?
No, but I knew he was under a lot of pressure, a lot of stress.
Did he mention that there had been any specific threats to him?
Nothing specific, but I just, you could tell the way he acted, it was bad. Bad. He was horrified. He was scared to death.
He was scared to death?
Yeah.
You don't know what he was scared to death of?
No, but, I had my theories, but
Well, let's not talk about theories.
that's my theories, but that's not what it was, that I know.
Okay, so you said you were up all night with him,
Yes.
and at any point did he go anywhere?
No, but he did try to get me, the daughter my mother adopted a child. And at the time she'd been at the doctor's office, had a headache, passed out, done MRI, she was in the bed. Well, Mickey at one point tried to get me to ride up by his house, just to check around his house and make sure it was all right. And he wanted me to leave her in the bed. Anybody that knows Mickey would have never suggested you leave a junior in high school in the bed by itself and it's dark outside to go check around somebody's house.
He wanted you to go with him to check on his house.
Yes, his home.
Had there
Yeah.
been something that made him want to go out there?
There was a guy walking down the back street behind his house and you could see his legs. And he was just walking down the alleyway, but it was enough to break him out.
What did he think was going to happen, if you know?
Just my opinion, I think he thought they was going to like circle around by his house.
And do what?
I don't know.
He said he was concerned about Caroline and Lila.
Mhm.
And what was it about Caroline and Lila? Did he mention anything specific to them, what he was afraid of?
He was just afraid somebody was going to hurt him.
I heard.
Yeah.
Now, you've known Mickey for a long time.
Mhm.
His whole life?
Yeah, he brought him home from the hospital.
You familiar with his normal behavior?
Yeah.
What's Mickey like normally?
He's a jokester. He likes to laugh, play. He helps people a lot. He's a good guy. Hyperactive. He goes out and does stuff without you having to beg him to do it, or ask him. If he sees you need help, he'll help you.
Was his behavior that night consistent with his normal behavior?
No, he acted different. I've never seen Mickey act like that.
If you had to describe how he acted in one word, what would you say?
One word, he was kind of psychotic.
Did he ever sleep?
Not while I was with him.
What time did he leave your house?
He left the next morning. Now I didn't look at the clock, but it was between 8 and 9.
Between 8 and 9.
Yeah, something like that. But I didn't look at the clock, so but it was early.
And at that point, had he slept at all?
No.
Okay. Did you talk to Mickey anymore after he left your house that day?
Yes.
And let me back up. Was that September 19th of 2024?
Yes.
You talked to him again after that?
Yes.
How many times?
I think he tried to call me once, a voice call, but then he did FaceTime me once from the courthouse.
From the courthouse?
Yeah.
About what time was that?
2:49 maybe.
2:49?
Yeah.
Okay. And that's PM, I assume.
Yeah, yeah.
So this is right before he gets down and starts putting in the work.
If I showed you a screenshot from a video, and Judge, this is going to be a screenshot from the video that the Commonwealth is going to do. If I showed you,
I'm sure in hindsight she's like, oh my god, he was losing his mind. You know, like he's wandering around making sure he didn't sleep all night. Yeah, maybe she got fed to her. Maybe she's like, Meemaw looks at it and goes like, God damn, the boy lost his mind. Like, I'm sure in hindsight, it's like, holy shit, he's crazy.
a screenshot of a video, do you believe that you could identify the person on the phone?
Okay.
Judge, if I'm incorrect.
Sure.
Jackie?
Or you wanted to mark that for the record?
No, Your Honor, I'm just.
Okay.
I'm sorry, say that again now.
To me,
You believe that's you?
yes.
And is that roughly the time? Let's see, I'm gonna go here. Apologies. Judge, if I can approach again.
Sure.
I have a time-stamped screenshot, Your Honor, of the video. 1438 I'm sorry, 1448. And that's you on the video?
Yes.
Okay, and that's the FaceTime call that Mickey made to you?
Yes.
And is that about the correct time that you recall him FaceTiming you? On that FaceTime call, what did Mickey say?
Well, like I said, my mother and daddy raised him, so he had a name for my mother. He called her Mommy Bones.
Mommy Bones?
Mommy Bones.
Okay.
And he called me and he said, Sherry, and I said, well, he said, let me speak to Bones. So he called Mommy.
Did you let him speak to Bones?
And she'd been dead 2.5 years. And I said, what? And he said, let me speak to Bones. I said, Bubby, where you at? Are you at the office? He said, let me call you back. I got a bad connection. I said, well, okay, call me back. He said, love you, bye. And that's the last time I talked to him.
That's the last time you talked to him.
That's the last time I talked to him.
Did you find that call concerning?
Yes.
What?
He asked for my mother twice. He was with me when I had to took my mother from the ventilator. So he knew she was gone. It was me and him together, had to unplug it. So he knew she was gone.
Again, has Mickey ever acted this way in the past?
No.
Did you eventually find out what happened at the courthouse that day?
Yes.
When did you find out?
It took until I found out for sure, about half an hour.
What was your reaction to that news?
My knees got kind of weak and my mouth fell open and I cried my eyes out.
Is that something that you could ever imagine that Mickey would do?
Never in a million years would I have ever thought that Mickey would even discharge his gun, let alone do something like that.
Has he ever been violent?
No.
Has he ever been angry, mean, rageful, any of those things?
You know, everybody gets angry, but I've never seen him violent.
Do you know if he's ever discharged his weapon?
Not that I know of.
Did you have an interview with the police after this all happened? And did you tell them that day what you're telling us today?
Yeah.
You said that you still have the Benadryl and the melatonin at your house.
Mhm.
Did the police come to your house?
No.
How'd you talk to them?
On the phone.
On the phone?
Yeah.
How many times did you talk to them?
Once was like an interview conversation, and then I think I may have had to call him back once after that because I remembered something. They told me if I remembered anything to call him back, but I can't remember specifically what it was.
Okay, but they never came out to the house?
No.
They never collected any evidence, medications?
No.
You kept in touch with Mickey at all since he's been in jail?
Yeah, I wrote him a bunch at first, but now it's down to just like FaceTime, and I'll go up and FaceTime, you know, with his wife, daughter, or something like that. Not as much as it was, but it's as much as I can.
Sure. You know how he's doing?
He's not doing good at all.
When you say that, what do you mean?
I mean, He's always had to take antibiotics every day of his life. He's got a really bad infection in his head. And it's not just looks wise, it's painful and it's getting on his face. His head's got these, it's hard to lay his head on pillows. He's in a lot of pain to the point. And this tick bite he got has always caused him a lot of trouble.
Tell me about that. You said he got a tick bite.
Yes, they call it California encephalitis or something like that.
Do you know what that is?
He went to and from the hospital so much, and they kind of acted like it was a mystery illness. Like, oh, well, we can't find it. Just go home and take Tylenol. But it just, his blood pressure would be up. It would be down, up, down. And it was, he just looked pitiful. You know, in that hospital bed, his feet hanging over him, acting like he wasn't sick, and they come to find out, run the test, that it really was something.
And what was it again?
It was from a tick bite. I think they call it California encephalitis.
California encephalitis?
Yeah.
And do you have any idea? I know you're not a doctor, but aside from just being tired, being in and out of the doctor's office and things like that, do you know in any way how that affected Mickey? What symptoms he had, anything like that?
No, it had a lot to do with tightness in his head and stuff like that, I think.
Tightness in his head?
Yeah,
Okay. Did it have any behavioral symptoms?
I don't know.
No. Okay. And that's fair. That's fair.
But now he does have really high blood pressure. He was born with a heart murmur. And he's just always had a lot of health problems, chest-wise. You know, heart, lungs, he had a hard time breathing. And it seems to be his health going down.
Health's going down.
Yeah.
Has Mickey lived in Letcher County his whole life?
Yeah.
All right. Born and raised. You brought him home from the hospital.
Yeah.
All right. Do his wife and your kids live in Letcher County?
Yes.
All right. I think you already kind of told us when he was sheriff.
Mhm.
What kind of sheriff was he?
He tried his best to help everybody, if he could, to give everybody a chance. Tried to help turn their lives. He tried to help their families too. If they were having a hard time with their kids, he tried to help.
Mickey got a criminal record?
Nope.
You know if Mickey has a passport?
No,
Has he ever been out of the country?
no,
Ever been on an airplane?
no. I'd have never heard the end of it if he had.
As far as you know, what's his relationship like with Caroline and Lila?
They seem to get along great. I mean, everybody has trouble, you know, but can't live with each other, can't live without each other, you know.
Now, if Mickey were to get out on bond, does he have a place to go?
Yes, always.
Where?
Me or them.
They still willing to take you in?
Well, yeah.
You willing to take him in?
Yeah.
He judge decides to give him a bond and he's able to make that bond. You think he'd comply with the bond condition?
Yes.
Would he show up for court?
Yes.
Would he take off and go to Mexico?
No.
Judge, if I can have just a moment.
Sure.
Oh. You said you had written Mickey some letters and things from jail. You ever FaceTime with him?
Yeah.
And do you do that just you and him?
I go up to his wife and daughter's house and then I FaceTime with him up there
How often do they FaceTime with him?
every day.
Every day. Okay. Now, you said, you know, obviously we've gone over how he was acting the day before. This all happened the day of. Since you FaceTime with him, since he's been in jail, what, close to 2 years now, right?
Yeah.
Have you noticed any of those paranoid type of behaviors at all? Does he seem like he's pretty much?
Chad, I forgot to talk about this. One of the other things they're looking for here is to show, well, they would like to get his bond reduced and he could stay with his aunt. He's got nowhere to go. Mickey Stines is from the area. I mean, think about it. You know, he's not like he's going to go to Mexico. He's got nowhere to go. He's kind of Poe. He's Poe! JDK says, I was raised by Appalachian Americans. I need no interpreter. Yeah, I mean, like, I didn't live in the Appalachia, but it's like, I grew up in the rural areas. I grew up in rural Ohio. I understand this woman 100% fine. Neutral Robinson for $2 says, Mickey's attorney is kind of cute, Wood. I think they're a husband and wife team, if I remember correctly. And then Connie Death Squad for $5 says, a southern aunt that doesn't want to be involved? Now I know she's lying. But she is helping. She's trying to get involved and help out. So.
back to baseline
He seems pretty,
even?
yeah. He looks really bad, but I mean, he acts kind of calm now.
So he looks bad.
He looks bad, but it's really, he seems like he's calm now.
Fair enough.
He's not in the state he's in like this.
Fair enough. Judge, I think that's all I have for now.
Any calls?
Yes, Your Honor, I just have a few questions for you, Ms. Stines. Let me make sure I understand this right. So Mickey wasn't acting right the day before to the point where you were concerned.
Yeah, he was acting,
And did you call anybody?
no,
Did you call his wife and say, what's wrong with Mickey? Something's wrong with him?
no, he was,
And the next morning when you got this phone call, you didn't call anybody. You didn't call the sheriff's department, did you? And say, hey, something's wrong with Mickey. Is he there?
no,
Did you? And you didn't call his wife that day either, did you? And say, Mickey's not acting right. You asked about bones. Is something going on? You didn't call her either, did you?
no. When he called and asked for my mother,
Yes, ma'am.
that was right before it happened, so I didn't have time to call
I
anybody.
think you said you had 30 minutes before you realized what had happened. So in that 30-minute window before you realized what happened, you didn't call anybody, did you?
It had already happened.
Right, but you didn't know that.
No,
Right, so you never called anybody between that
Sure
time and the
didn't.
time you found out.
no,
And you've spoken very highly of Mr. Stines, but my understanding is that he's concerned for his wife and daughter. Is that right?
Mhm.
And he left them home alone. With your house. Is that what you're saying?
Mhm.
He didn't stay in the driveway. I mean, they were upset because he's walking around and keeping them up. He didn't go to the driveway and sit in the car, did he?
I don't know if he did that or not.
He left them with your house, correct?
Yeah, he did come to my house, but I don't know what he did before that.
And what time did you say he showed up at your house?
I don't know exactly. I didn't think it was going to be important at the time, so at the time I didn't notice.
Now, I think most people at this point in time, you've been arrested in Letcher County your entire life, haven't you?
Yeah.
And I assume you've seen this video also, haven't you?
What video?
The video in Judge Mullins' chambers.
Yeah, just once, part of it, yeah.
And you know who Kevin Mullins is, don't
Yeah, I
you?
know Kevin.
He's district judge.
I know Kevin.
He's a district judge, correct?
Yeah.
Was a district judge.
Yeah.
Better way to put it. And you saw.
I
Did you
saw,
shoot?
yes.
Oh, I know.
Thank you, ma'am.
But just briefly,
Sure.
when Mickey came to your house, you knew that he'd been to the doctor that day.
Yeah.
Okay. And you knew that there'd been some concerns about his mental health.
Yes.
And that was the reason he was taken to the doctor.
Yeah.
And when he was at your house, he kept the cameras on at his house all night long.
Watching his house.
Did he ever turn them off?
No,
Did they keep you up at night?
I could hear the little crickets and jar flies all night.
And was he concerned the entire time about what was going on with his
Yes, he
life?
was. Yes, he
All
was.
that.
I thought he was there.
All right. Thank you, ma'am. You may have a seat. Any other witnesses?
Judge, I have a pretrial officer that interviewed Mr. Stines prepared to testify, but if the court can take judicial notice of its own report, then that won't be necessary. We can release that witness.
Sure.
No objection to the court here.
That's all the witness.
All right. Anything to the Commonwealth?
Nothing else.
All right. Ms. Barley, any argument?
Your Honor, I will ask the court, understand the court's ruling in order, I believe, in December, regarding the report from
Did he have a mental break? I mean, it kind of sounds like he lost his shit. I mean, it sounds like he went crazy. We don't know, though. We don't know. Does anyone know if it involved his daughter? It doesn't sound like it. It doesn't sound like it at all. So, yeah. Oh, Karen says, I didn't know he's in jail this entire time. Well, yeah, he's like... Well, I mean, if your part of your claim is he went insane and murdered people, it's really tough to say we should have him out on bond at this point. So, your only defense is that she's shifting her weight a lot. Yeah, but it probably doesn't help that she's not sitting like behind a podium or a lectern. That would help kind of hide that. But I understand where you're coming from. Once you're diagnosed with mental problems, maybe being sheriff is a bad idea. Yeah. I mean, but we all have mental health issues at some point or another. There's nothing to stigmatize that. So, and Karen, when you say the Glowies would never release bioengineered ticks in Appalachia, so we still have no idea why. Yeah, we don't know for sure. We don't really know for sure. Sounds like he probably had some sort of paranoid delusion and fucking smoked them.
Dr. Allen.
Yeah,
I will-
and I will take that under consideration.
Yes, Your Honor.
in that instance.
Yes, Your Honor, thank you. That's absolutely an issue that we want to make sure we resolve. Judge, in terms of argument, it's the Commonwealth's burden to establish that the proof of Mr. Stines' guilt of a capital offense is evident or the presumption of his guilt of a capital offense is great. Now, the cases say, and again, Markham v. Broughton sets the standard that says where conflicting evidence creates a plausible basis for self-protection or the reduction of the offense to a non-capital degree, the Commonwealth has failed to meet its burden and he's entitled to bail. Judge, the Commonwealth here, the only proof they've put forth is a video. And while I agree it's a compelling video, it absolutely is compelling evidence. I understand that. But the only thing that the video shows is an act and an identity. We don't have any element of intent. And the murder statute, Your Honor, anticipates, it actually makes an element EED. EED is an element, or the absence of EED is an element, right? So they have failed, Your Honor, to put forth any proof as to the mental state, any premeditation, anything to that effect that would be necessary to take that and make it an aggravated capital offense. And our evidence, Judge, while it's been brief, we have Ms. Stines, we have the court taking judicial notice of certain pieces of evidence of the pretrial reports. I believe that that creates enough of a presumption, Judge, or enough of a plausible basis, which is the standard under the law, to show that Mr. Stines acted in such a way that a jury could believe that he was either operating under extreme emotional disturbance or potentially even insanity. And I understand the court's ruling again on the insanity argument, right? That, that's an affirmative defense. That's for trial. We're not having a mini trial here today on whether he is insane, whether he had the requisite mental state. But all of that proof, or the absence thereof, goes to whether or not he's bailable. And that's the only thing that we're looking at today. Did their proof meet that burden? Now, I think evidence put forth by our single witness, Judge, and then of course what the court is going to take notice of, demonstrates that there is a plausible basis that this comes out of the capital murder arena. I think evidence that he was, Ms. Stines testified that he was acting out of his character, that he was paranoid, that he was having concerns about the safety of his wife and daughter. And the standard for EED, as the court knows, it's not an objective standard. It's not a reasonableness standard. What a reasonable person would think, it's what he thought. What did Mickey Stines think was happening at that time? Why was he in fear? Why did he believe that his wife and daughter were in danger? And he clearly did. Now, the Commonwealth makes much of the fact that he left his house and he was at his aunt's house, but I don't think all that matters when you look at his mental state that he had at the time. He was completely out of his typical character. And, the court will take a look at that video. And again, it's compelling, but I think there's so much more, Judge. And although the court, again, said that, insanity is not necessarily relevant at this stage, the cases that we look at, there are several cases that say that bail should be granted in a capitally charged case. And I think it is relevant. The Commonwealth hasn't filed a notice at this point, right? So RCR, I believe, 402 says that.
As we discussed earlier, that's being held in advance at this point because there's outstanding issues in regards to that.
Sure, Your Honor. What I'm saying, Judge, is that.
Let me ask you this, Ms. Parker, because I do want to kind of move things along.
Yeah, absolutely.
What is the bond you're proposing?
Judge, what we requested previously was $50,000 cash or property, Judge, with any conditions that the court deems appropriate. The court has heard all of the proof on, he'll have a place to stay. He's not a flight risk. He has no criminal record. He, in terms of the pretrial risk assessment, he's a low 0, the lowest that he can be. There's no reason to think that he wouldn't be compliant. He wouldn't reappear. There's no reason to think that he would reoffend, Judge. So we would ask for that, but with conditions. I think there are sufficient conditions to ensure his appearance, sufficient conditions to keep him and the community safe. An ankle monitor would be appropriate, Judge. No movement, GPS monitoring if necessary, no firearms, clearly. I think the court can fashion any number of remedies to allow him to be out in the community and prepare his defense outside of the confines of Leslie County Jail. And so we would ask for that same bond, Your Honor, but of course, whatever the court deems appropriate, I'm just asking the court to find that he is in fact available and to set a reasonable bond.
All right, Mr. Steele.
Yes, Your Honor. I want to point everything she mentioned regarding insanity. Those are all defenses to every one of them. We're not here for that at this point in time, but in regards to the bond, I'm going to point the court direction of Commonwealth v. Jones. I believe I got the court last time. It's 2024 Westlaw 2982769. And in that case, out of Breckenridge County, the Commonwealth chose not to seek that. And at that point in time, the circuit judge says that I'm going to grant a bond. There's a long analysis of that in regards to criminal rule 4.02. 4.021 says everybody is entitled to bond except those charged with a capital offense. And the conclusion, I'll read the conclusion in the last chapter. Jones was charged with capital offense, which death was a possible penalty. Per Kentucky Constitution, Section 16, we believe it's incumbent upon the circuit court to make an express finding as to whether the proof of Jones' guilt is evident or the presumption is great, to one or the other. Accordingly, we reverse the orders of Breckenridge Circuit Court granting bond and setting conditions of release remain the matter for determination of whether the proof of Jones' guilt is evident and the presumption is great. If the court answers the question in the affirmative, then Jones is not developable. The evidence is that Judge Mullins was a public official, which is would make this a capital offense. So we do not believe he is a available defendant based upon the charges.
Your Honor, if I may just respond to that.
So, I mean, this is that thing, though. You go back and forth a little bit, and the judge is like, all right, I'm not going to fucking let him out. I think they all know that. But
Briefly, Jones, Your Honor, as the court knows, and cited in its order that was dismissed as moot. I don't think the court ever reached the ultimate question, so it's still an unsettled matter of law. But the analysis is the same,
Sure.
Judge. So I don't think that case is really relevant at all to the court's view.
All right, I will get an order out on bond. I am going to be real honest, the thought of a $50,000 cash or property bond is something the court would not entertain. If the court does believe that he is available, this would be a bond that would be much more significant than that. But the bond is something, this would be a bond that would be.
I mean, that's the thing. He's not getting a $50K bond. He's probably going to have a $500,000 of $1 million bond. He's going to have a big fucking bond. But frankly, the judge is not setting it. Once again, you've all said he's crazy. Well, we're not going to let crazy people out on the streets who murder people. We have an interest in not doing that. So what were you guys? Oh, David Lego Raid. Hello, all of you Lego peoples. Hello, guys. Now, some of you guys are saying this courtroom's horrible. Yeah, but this is where the world is. Seller says, "Where's the witness stand?" Well, it's a term. When a witness is coming into the court and testifying, they're on the stand. So that witness stand was that old lady standing in front of the lectern. Stace says, schizophrenia onset is mid-20s. Yes. For men, it's the 20s. And for males, if you can make it past if you can make it to 30, you're safe generally. Like there's age ranges for it though. And for men, generally, yeah. If you can get to 30, you're generally okay. You know, and for women, it's till you get to your mid-30s. That's kind of the danger zone. But for men, it's like your teens to your 20s. But then there's late onset. It can happen. And that's the thing. Like, I doubt this guy's schizophrenic. And that's why, even if it was schizophrenia, 45 is a weird time frame for that. Generally, when you're older, like old people could develop schizophrenia. That's not the only age range. The most likely age range is basically from 16 to 30 for men. And then for women, it's like 20-something to 35. You could still develop it in your late 50s to early 60s, but generally that's pretty rare. Most people getting schizophrenia, it happens in their adolescence or early adulthood. So there's a whole thing. Your thing is schizoaffective, not schizophrenic. Yeah, that's also a thing there too. And there's a difference between those. You know, well, like both of them have like hallucinations and delusions. Schizoaffective guys, and this is getting into some mental health weeds. You have a lot of mood swings with schizoaffective disorder. It's a very different thing here, but I could definitely see that. Yeah, there's many things that make you paranoid beyond schizo. Yeah, we just don't know what happened. We don't know what happened to him yet. Yeah, there's a whole range of schizoid disorders as well. So, sleep deprivation could be an issue too. We just don't know. I doubt it's sleep deprivation though.
Much more significant than that, but I'm going to rule hold that in advance and get an order out to you all in regards to that.
Yes, sir.
Next, we've got a petition for change of venue.
Yes, sir. If that is a Commonwealth motion, we have attached 3.
Oh, yes, this is the part I wanted to hear. The prosecutors are asking for a change of venue. I think that it should be almost prohibited for prosecutors to ask for a change of venue. You're not entitled to a change of venue as a prosecutor. And if you can't try the case where it happened, tough fucking luck. The prosecutors should not get allowed to change a venue like this.
Davis to that also, as we played out the law for the case, I'm not going to go further. There was an attachment also, I believe, the original motion showing also the news coverage, not just locally, but also nationally. I did just a little search.
Yes, Mario, as I say, the prosecutor does not have the right to a fair trial. If nobody likes you, that's a you problem. That's not a we problem.
Yesterday, and updated some numbers. It appears the Mountain Eagle, which is the local newspaper for Letcher County, has had, at this point in time, had 103 articles written on this. They have a Facebook page, over 30,000 members on their Facebook page.
Enrico, we don't actually know. That's the thing, man. We don't know the answer to that. Like, it sounds like it may have been in his head. And notice, this guy's bringing up, oh, well, the people on Facebook and they don't like us. Well, like, okay, so what? So what, man? Like, oh my God, you're crying about everybody on Facebook who doesn't like you. Now, the funny part is there's a 30,000 person Facebook group. Chat, here as of the 2020 census, Lonoke County, 21,548 people. So this guy's already complaining about a Facebook group that's larger than the county itself. So are you going to get a fair trial anywhere? Are you going to get a fair trial anywhere? I guess not. But notice, listen to the crying here. 30,000 people on Facebook don't like them. So he's already pointing out it's not just in this county, it's everywhere I go. Yes, this is a national story. I remember when it happened, I was actually talking to a judge. Like, they took notice of this. A fellow judge just got smoked. Like, he got smoke checked in, like, his chambers by the sheriff. Not just some rando walking with a gun, by the people who are allowed to carry guns in the courthouse. This made some judges I know pretty uneasy. So this is going to be a nationwide thing. And I will tell you, down in that area of Kentucky, I mean, in Kentucky in general, and Appalachia in general, people are not, people believe in law and order, but they aren't necessarily fans of the law. Like, they ain't fans of the sheriff, generally speaking. They ain't fans of the law. Law is something that gets in their way and gets in their business. So I don't know where this guy thinks he's going to get a fair shake. And to be fair, that's really and if you guys are from like the Northeast, this is a vein of things in the Midwest in general and most of like non-coastal America. Like, you believe in law and order, but you don't necessarily like the law. But in Appalachia, that's something that's like in people's DNA. Chat.
And he was very strong with his opinions as to what it was. Not just based on news stories, but based on just rumors and word of mouth and some.
Right, Chad. Sorry, Chad. Sorry. Here we go. Sorry. Here we go.
Yesterday, and updated some numbers. It appears the Mountain Eagle, which is the local newspaper for Letcher County, has had, at this point in time, had 103 articles written on this. They have a Facebook page, over 30,000 members on their Facebook page. I believe of the 103, I believe the number I got was 20 of those were speech or peace articles, in which people can just say what they want to anonymously. And then there's comment, as you can imagine, in every direction. This was the stop story in 2024 on both the Mountain Eagle website and on the Mountain Eagle Facebook page. WYT News, with a local, I'm going to say Southeast Kentucky, has had 33 articles, news coverage in the last 12 months, I believe it is what I showed. And I'm not going to say what people say because obviously I'm being quoted.
Sure.
But suffice it to say, a large number of the community has strong feelings one way or the other. And it's just not in Ledger County. I was had a conversation with the victim's family in Perry County just 2 weeks ago. And of course it came up, and he was very strong with his opinions as to what it was. Not just based on news stories, but based on just rumors and word of mouth and some outlets that, I didn't get into the YouTube bloggers, which has been insanity, to say the least, in regards to theories and things they're saying out there. I believe defense counsel's even commented on some issues as not being true, that have come out in those. It's our position, Judge, that the news media coverage in Southeast Kentucky and even Central Kentucky, because the IMT has their sister station, the Lexington channel, the coverage has just been unbelievable. I could go into Facebook pages all over Southeast Kentucky and find strong opinions. The market changes when you get to Western Kentucky in regards to where their news has got where they receive their news. You really receive news on the national network and not the Lexington or South Kentucky network. So that's our position, Judge. The affidavits are of a practicing attorney, of the county attorney, and the county attorney. The county clerk and the circuit clerk weren't available the days I was over there. I think they realized what was the docket. They both got out of town. So those are the people that I could catch up with. I can tell you I could get these signed by almost anybody in Ledger County. And these individuals that ran for office have a finger on the pulse.
Thank you, Steve.
I mean, yeah, it's a big deal, but as you stated, everywhere you go, people are talking to you about it. So what are you gonna do? He's calling you out, blogger man. He could suffer. Yes, potentially insane blog man, yes. Yeah, this guy would shit his pants if Turtle Boy came after him. Although down in this neck of the woods, they'd throw Turtle Boy in a fucking holler. I'll tell you that much. Like, I don't, Turtle Boy did God's work for Karen Reed, but like, he thinks the police corrupt up there. Dude, they would have thrown him down a fucking a mine shaft out there. So, yes, give me special power because people are exercising speech. Yep. Let me go somewhere else, Judge.
Yes, Judge, we had subpoenaed the people that had signed the affidavits to the change of venue, and I think one of them is Miss Ashley, Ashley Fields.
Right.
If I could call her.
Sure.
Is Ashley Fields here?
Yes, sir.
Thank you.
Ma'am, would you raise your right hand and swear? Do you swear from the testimony you give me the truth, whole truth, nothing but the truth?
Yes, I do.
Please state and spell your name.
Ashley Sturgill, ASHLEY STURGELL.
Oh, I'm sorry, I thought it was Fields. I don't know where I got that.
I'm married, but I did not change my name.
And you state your name for the record. Where do you live?
I live in Whitesburg in Lake County.
And is that like, do you live in a community or do you live in town there?
In the community, in town.
What is your community's name?
I live in Whitesburg in the upper bottom there.
Okay.
I live in Whitesburg. Upper bottom, that is an actual that's a term of art in the hills. But she lives in Whitesburg. How white are you?
And have you lived there all your life?
No.
How long have you lived there?
I've lived there for approximately 3 years.
3 years.
Yeah.
Now, let me ask you, do you work anywhere around the courthouse or anything
Upper
like
Bottom's an actual neighborhood? Okay, like Upper Bottom also sounds like a term of art in the hills too. But okay.
that?
I'm an attorney in town.
Okay, and what kind of law do you practice?
General practice.
Okay. And did you happen
So now we got an attorney testifying. Okay.
to be in the courthouse the day of this occurrence?
I did, yes.
And so you could technically be kind of a witness.
Yes,
Would
that's
that be
correct.
right?
Yes.
And did you have any emotional feelings about this?
I was there that day, so I think,
Did it shake you up?
of course.
Okay.
Yes.
And so when would you have moved to Whitesburg there?
I think I moved in the fall of 2022.
Okay. So you lived there approximately 2 years, would that be right, at the time of this occurrence?
Yes,
Okay, in that same place?
different places in town. I've lived several places.
Oh, okay. Let me ask you, you state in your affidavit there that, in support of this motion to change the venue, let me ask you, what public opinion, how many people are in a public opinion?
I think it refers to the state of public opinion.
Well, that's what I'm asking. Can you show you what you're saying?
I've got a copy of it.
Okay.
So.
Well, I just wanted to know how much.
Uh-oh. I forgot, chat. This is where it gets all garbage for a minute, so we're going to keep going here. I don't know what they're saying, guys.
Okay. All right. And tell me something. Do you practice any criminal defense, anything like that?
Yes.
So you understand when you said that the Commonwealth could get a fair trial. Is that right? That you said even they could?
I think I said both.
Both
neither
parties.
party
Well,
could get
neither
a fair
party
trial.
could get a fair trial. I'm just going to talk about the Commonwealth.
Yeah.
You understand that as a criminal defense, somebody that does that you start off with a presumption of innocence in every criminal case.
Yes.
Presumption of innocence. So already the Commonwealth has got a burden to go over to overcome that presumption of innocence. Isn't that right?
That's correct.
Okay. And what to you is a fair trial for him, Mickey Stein?
Again, I don't believe either party could get a fair trial in a community where that you have a victim and a defendant who were both elected public officials in that community, which inherently brings with it a lot of love and a lot of hate and strong opinions toward either.
Okay, but I'm just saying in a trial, could you understand why a person would want to be tried in their home county?
I can see why people would want to, but I can't see why anyone would want to in this situation.
And in this public opinion that you talk about, have people expressed to you that no matter what we hear in that case, in that trial, we're never going to believe anything the Commonwealth has to say?
Excuse me, can you repeat that?
Has any of those people that you said have public opinion, has any of them expressed to you that no matter what is said in the trial, I'm not going to believe anything the Commonwealth puts forward?
There are people who have taken strong stances on either side,
But-
very publicly. Now, do I think that someone would come in and admit some sort of inherent bias? No, I don't think that people even realize that they have that usually. I don't think someone would walk in here in front of all these people and admit to being racist, for example.
Okay, race isn't an issue in this case.
I know, but I'm just
Okay.
saying those types of inherent biases, I don't think people would be willing to just freely admit to that.
True, but that's in any case you try, no matter what kind of case it is.
Correct, where there's some sort of bias.
There might be a bias about anything. True. And all the court can do is ask, all we can do is ask questions.
I mean, the idea that she volunteered to be involved in this, like this, I mean, this is gonna hurt her fucking street cred as an attorney. This doesn't look good when you're like, she's voluntarily helping them. This is bad. This is so bad right now. Yes, and they are trying to do a change of this is a change of venue at this point hearing now, yes. I don't yeah. That's because she's running for Mullins' seat, Lamal. Well, he's dead, so anybody can run for it. I just yeah, you see, the problem here is that people hate the government. Yeah, I don't understand why they're doing this. I don't understand why she's getting involved here. This just doesn't look good. This doesn't look good. This isn't how you look good in the community. Oh, so she lost on top of that. Good.
And go by the answers that the people give, right?
Correct.
And you're not here saying that the Letcher County people would get false information under oath about on board hire, are you?
No,
Okay.
what I've just said is that, and I'll repeat that, I think that most of the time when people take strong stances, they don't.
She's basically saying that nobody can get a fair trial. She's supporting it moving. This just looks bad. Like I said, when you're a defense attorney, man, you don't go sell out other defense attorneys. This is disloyal shit right here. I wouldn't fucking trust her to let her plea out fucking parking tickets.
Don't even realize the bias that they actually have.
But no matter what, he's presumed innocent.
Correct.
He starts off right there.
Correct.
So there's a bias there. Isn't that kind of a bias that if he has to start off being presumed innocent?
No, so and she signed an affidavit that the prosecutors are using in support of changing venue. Because remember, the prosecutors want to change the venue. The defense attorneys want to keep it here because they're going to get a lot of people to say, fuck it, I like Mickey. Not guilty. But this woman is disloyal. So yeah, it was on video, but if everybody says, fuck it, I hate the judge. Not guilty, not guilty is not guilty. So.
Presumption of innocence. Yes, ma'am.
I don't know that I would consider that a bias.
Okay. And let me ask you, did anybody ever express that no matter what the Commonwealth put forward, we don't believe it and we're not going to pay any attention to it?
I think people have expressed that in other words. Yes, people have continued to, even locally, to have opinions and very publicly and support certain rumors, which I think Mr. Steele hit on, that even the defendant's own counsel has now said on numerous occasions are not true. So, yes, that's the answer to that.
Okay, let me ask you something. I'm just curious again. I'm just wondering how many people have you expressed this opinion, or how many people are you saying are in a public opinion?
Sir, too many that I could count over the last year and a
What's the
half.
population?
Several thousand.
Let's go.
I think, I want to say, I don't know.
Okay.
I don't know the answer to that.
Yes, ma'am.
Small community.
This is not looking good for her. God, this woman's selling out. Why is she selling out? Why is she selling out like this? But yeah, I agree, Mario. I'm never sending her business. I can't imagine making her friends in the defense bar. Not sure. Says besides crazy, what other defenses does the guy have? There's always the defense of he needed killing. Sometimes the guy that got killed deserved it. That's about it. So, yeah, and it's this is a defense attorney saying the state's entitled to a fair trial. But guys, to be fair, most attorneys don't even think about that or make that point. She's only selling out because her only asset is her bottom. Yeah. Gotta say disloyal like Ralph, you disloyal bitch. She's disloyal.
And now you're just in private.
You know what, Chad? She's an A-log. She's an A-logging attorney. The goddamn A-logs. And this right here, this guy here is I guarantee you this guy's suspender flicked before in court. This guy right here, this dude has seen some shit. He is salty as fuck. But yeah, here we go. He is he's dealing with the goddamn A-logs.
Right.
Yes.
Were you ever the county attorney or in the county attorney's office?
No.
Okay, that's fine.
Which also means that while the husband and wife team, I think they're husband and wife, they have probably a good repertoire or rapport with this judge. This guy and that judge definitely know each other, and they go way back.
Did you know any of these other folks here? Mr. Matt Butler? Did you know him?
Yes, I know him.
And do you know Mr. Holland?
I'm not going to, I'll tell you this much, Chad. If a prosecutor came to me, hey, would you write an affidavit for us? Fuck you. I don't care what it's about. I'm not unless I'm the victim, or something like that, I'm not writing, especially something like this, definitely ain't doing that. That sounds like a fucking you problem. What's in it for me? Nothing. Well, are you going to dismiss every case I ever get with a client in front of you? No. Well, then I ain't dropping it. Then I ain't doing this.
Is that his name? Howard? I'm sorry.
Mr. Hatton.
Yeah, Hatton.
Yes.
That's it. Yeah.
Yes, I'm familiar with those.
Okay. And that's people you've talked to?
Do I think that it's this attorney and the judge, do you think like we dug coal together? No, I don't think they're like Raylan and I don't think they were that way. I don't think they were that way. I don't think they were that way. I don't think they were like Raylan and Boyd. We dug coal together. No, but they might have.
About this too?
I talk to them regularly,
Oh, Boyd Crowder.
through work. We work together.
And who asked you to fill out an affidavit?
The affidavit that I signed was presented to me by Mr. Steele.
Thank you, that's all.
Separate, I've got a few questions. My role's a little different than Mr. Cox, and he's worried about his client. I'm worried about justice on both sides.
See, fuck you. You are not worried. Like, this is bullshit. I'm worried about the justice on both sides. Fuck you. Oh, fuck that. Well, I'm worried about justice on both sides. No, you're not. No, you're not. It's a lie. That's been fact-checked by real patriots to be a lie. Motherfucker.
And he's just concentrating on the Commonwealth not getting a fair trial. Micheal Stein has a presumption of innocence, right?
Yes.
Is it your position that if he was to be tried in Letcher County, that Mickey Stein would not have that presumption when he walked in a courtroom in front of a jury?
I don't.
Objection, Judge. Objection. Can you approach the bench here?
Sure.
This used to be me as a assistant prosecutor. I never made an argument like this. We never had shit like this happen. You know, also, yes, that's his right to assert. Yes, I agree. Yes, this statement was fact-checked true by true American patriots. It's not, the guy does not look like John Kasich at all. Does not look like John Kasich at all. Like, not even close. Guy looks like he played like linebacker for Kentucky, though. Or safety.
Have preponderance of that.
Here we go.
I'm sorry, could you repeat it?
Is it your opinion after talking to people, and I'm going to get that just a little bit, that Mr. Stein would not have preponderance of evidence when he walked in on that first day of trial? Presumption of innocence, I'm sorry, presumption of innocence.
I think that it would be hard to there.
And is that, you kind of talked, is that because of the mindset of people either for or against him?
Yes,
And you do criminal defense, correct?
yes.
How many times have you had criminal cases that have had over 103 articles written on it in the Letcher County paper?
I have not had one yet.
Okay. You've had voir dire, talked
Yes,
about voir dire. That's one of the issues you go over, isn't it?
yes,
Is media coverage.
yes,
You said you're in general practice.
yes.
How many, of course, most people don't understand, but just walking in and out of courthouse, people talk to you on a regular occasion, just pull you out, hey, I need to ask you a question.
Of course, yes.
So how many people, I'm not asking you to guess, but just give us how many people do you think you talk to on average in a week in Letcher County?
Oh, I couldn't say. I would say,
I couldn't guess.
yeah, I
It's
don't,
fine.
it's a lot.
Sure.
Too many for me to remember on
How
a daily
long have you
basis.
lived in Letcher County?
I've actually lived there since the fall of 2022, but I've worked there in practice since 2019 in the summer.
So you are familiar with the community.
Yes,
You also, you know quite a few people in the community now.
yes,
Is that just in Wattsburg, or is that in different areas of the community you know people?
all over the county in different areas.
And
And yes, the judge is the one who decides whether or not the change of venue is granted. Now, notice what they're not doing here. And this is interesting. And this is, I'm kind of surprised in a little bit, because when we talked about the change of venue, like at Brian Koberger or some of these other cases, you need, like, generally speaking, and I've talked about before, you need like statistical work to be performed, you know, surveys and polls and all of that. Notice both sides haven't really brought that up yet. And I think this shows you we're operating in a little bit of a different world here. That, you know, statistics and surveying and polling, None of that's applicable here. None of that's an actual situation here. So how would that work? Well, it doesn't sound like that's going to be an issue that they're going to fight over, which, we can, I think that's something to take into consideration, because normally when we talk about this, like, you need a lot of statistical work to support your data. In this case, they've got a couple of anecdotes in the form of affidavits. I think it's very interesting how this is being done. And the problem is, this is a county of 21,000 people. Like, that would actually be like these companies that do all the work for like Brian Koberger and then all these other places. You could actually do a pretty significant statistical analysis of this entire region, because most of these counties have like 20 to 30,000 people. So it's pretty easy to handle. Just something to think about. Something I just kind of realized.
I'm just curious, how many times does the conversation turn to this case? And just a general, everybody getting together?
Absolutely, all the fucking time. This is huge. This is going to be huge.
Sitting around talking. How
We're going to be talking about this shit for decades in Lecter County, Kentucky.
often does this case come up?
Very often, unfortunately.
When you're talking to people, and I'm going to not talk about people.
Unfortunately, what's so unfortunate about it? Holy shit. Why are you so unfortunate? Can't they do a phone survey? Not everybody's got phones down there. I'm joking. Yeah, I guarantee you this is all they talk about. This is like unless the high school football team's going to state. Like, a county of 21,000 people? Holy shit. This is all they're going to talk about. In a county of 300,000 people, this is all people will be talking about. How many times does his name come up? All the fucking time. All the fucking time. Guaranteed. And Luke is saying, yeah, so at most 7 years in the community, and you think you're a spokesman for the community. I agree. There's all kinds of shit here. Yes, the pillar of the community affidavits were the main way of doing it. The statistical analysis is a new creature, but it's what you have to do now because almost everybody loses their change of venue arguments. So it says 21K, and probably only half of that is jury eligible. But based statistically, yes, most people, like half the population is over the age of 18. But then the amount of people who would show up is going to be lower. And then, the amount of people who can do it, yeah. Yeah, and that's the thing, Mario, you're right. If this was Mickey's side of it, they'd say, look, just tell the jurors to keep their minds open. In your honor, when you tell the jury instructions, we know they listen to them, blah, 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 blah. Yeah, that's all the bullshit that would go along with this. Yep.
The people in the community, as you say, is it your position that they have strong feelings as to innocence or guilt one way or the other?
Yes.
Is it fair to say that there are rumors going around the community?
Yes.
That people do believe, regardless of what's been said, that the Commonwealth would not get a fair trial. That people have said, and I've read, I'm sure you have, and I hate to quote people on the internet, but people in the community that said he should be free.
Yes.
What he did, he should be free. I think I've read one, he should be given a key to the city or something like that. Have you heard those type of comments?
I've seen them and heard them. Yes.
And those are from people in Lecter County.
Yes. Those.
All of the age of being on a jury panel.
Yes, they appear to be adults on Facebook and various social media platforms. Yeah.
Now, when I see something on Facebook, I may not know who they are. I'm assuming when you see names on Facebook, like if I did in Laurel County or Knox County, I know some of those people. When you talk about these people that are saying things, are you talking about the unknowns, the anonymouses, or the people that like, oh, I know them, that represent their kid, or I did a will, I did. Are you talking about just people you know that live and reside in Lecter County?
Yes, I've seen it from people that I know or know of, and I've seen it from random people that I don't know. But I've definitely seen a lot of commentary that does appear to be people who are local, either taking one strong side or the other.
And if this is would you say this has been very divisive in Lecter County?
Yes, absolutely.
That's all I got.
Very few questions.
Sure.
That's all right. Ma'am, how long have you practiced criminal defense?
Since 2019,
And was it just in Letcher County or is it in other counties?
other counties as well.
Okay, you weren't by any chance public defender, were you?
No.
Oh, because they practice in other counties too, but I just want, let me ask you, how many changes of venue have you ever asked for?
I don't know.
Have you ever?
I don't know if I may have at one point, but I don't know.
Okay. Usually you ask for a change of venue because there's kind of a.
Are you talking just in a criminal case?
Yeah, criminal case, yeah.
I don't think I've asked for one in in any of my criminal cases, but I have asked for it in other cases.
Okay. But like civil cases or something like that?
Yes.
And in your experience as a criminal, just in criminal defense, how many
That means I don't know. Not having the best criminal defense experience here, but
times does the Commonwealth ask to move one of your cases to another county?
No, not yet in my career, but I don't believe that's
in 12 years, I've never had this happen. I've never even, as an assistant prosecutor, I never asked for it.
uncommon in high-profile cases.
Well, I understand that, but I mean, you've never had a case that the Commonwealth's ever asked for a change of venue.
No.
Okay. And let me ask you this, would you know if this case has been, I mean, where would it go if it was changed? Where in the world would it go? Because it sounds like it's just almost worldwide.
I am not the one in charge of that, so I don't know.
Yeah, I got you, but you can, but what I understood you to say is that just massive amounts of publicity and talk, social media and all that other.
I don't think anyone in this room could deny that.
Okay. That's all. Anybody else?
Ma'am, has there been anybody you've talked to in regards to this case that you don't believe has already formed or expressed an opinion on the guilt or innocence on this case?
Judge, I believe people have already formed their opinions.
On this case?
Yes.
You're in the courthouse every day, or not every day, but at least every week in Letcher County.
Yes.
In your opinion, in your conversations with the citizens in Letcher County, is there anybody you've talked to yet that hasn't expressed or formed an opinion on this case?
There have been people who, of course, they want to ask questions,
Sure.
but, no, I think that for the most part, I feel that for the majority, people have formed an opinion already.
All right, thank you.
Thank you. Thank you, Your Honor.
Any other witnesses?
Mr. Jamie Hatton.
Jamie Hatton? Sure.
Yes, sir.
And see, this is the funny thing here. These people signed their affidavits, but the defense is actually forcing them to show up and testify. So it's like, you wanted to get in this case. You're in it now, bish. So, that's what you get. That's what you get. Oh, I got a weather bug notice for up at Cleveland. There is a storm warning. The nearest storm is on the way. Oh no, that's not good. Clyde would have been having a rough night.
All right, Mr. Hatton, if you would, please raise your right hand. Be sworn. Do you swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You can change now. Please state and spell your name for the record.
Jamie Hatton, Jamie Hatton.
All right, thank you. You may ask.
Thank you, sir. And Mr. Hatton, where do you live?
Plattsburgh.
And do you hold any position, elected position or anything like that?
Yes, I'm Letcher County Attorney.
Oh, okay. Who asked you to sign a petition for a change?
Mr. Steele.
Okay. And as the county attorney, did you kind of recuse yourself from any prosecution in this case?
No, never came up.
Okay. All right. I didn't see a preliminary hearing last time. All right.
I was Mr. Stines' attorney at the time of the Commission of Defense. So
You were.
I was there.
I understand. And let me ask you, when you say community, how many people is there in Whitesburg?
About 7,000 people in the city limits, 20-some thousand in the county.
Okay. Now, you certainly haven't talked to every one of them.
No.
Okay. How many you guess you talked to about this guy?
To guess, hundreds, I would imagine.
Okay. And I know that, has anybody just said that I am going to not believe anything the Commonwealth says about this case?
No one said that.
No one said.
Not 20.
Anybody said, no matter what's said, no matter what's done, I'm going to find Mickey Stines not guilty?
No one said that to me.
And you agree he has a presumption of innocence?
Sure.
Okay. So you're a prosecutor, right?
Yes, I've sat at this table and at that table as well.
Okay, I got you.
Sure.
And what is a fair trial for the Commonwealth? What does that mean? If he has a presumption of innocence,
Here we go. Here we go. This is what you got to do, chat.
You already start with something right off the bat.
I think fair is subject to the eye of the beholder. You know, what's fair mean to you?
Well, that's a good question. But I'm just going to ask you this. Would it be important, do you think, and Mr. Stines hadn't asked for a change, do you think it's just about equally as important that he be allowed to stay in his own county and place his trust in the people of Letcher County to judge his case?
Sure.
You think they can?
I think who can?
Do you think the people of Letcher County can judge his case fairly?
I mean, I've got a great respect for the people of Laker County, but I couldn't imagine, you would almost have to have 20,000 jurors in there to try to find 14. Well, you know what I mean? I don't really strong opinion.
I understand what you mean.
Yeah.
But I mean, do you understand, should have
Notice he has to be careful because he's an elected official, but I understand him selling out and signing the prosecutor's stuff, but the defense attorney still makes no sense to me.
person be able to be, those people put their trust into Mr. Stines when they elected him. Mr. Stines put his trust in them. Do you understand it would be important to him to be tried in his own county?
Yes.
And they would be fair.
I don't know if they can be or not, honestly.
Okay. Would they be honest and say, no, I can't be fair?
I hope it's happy to say. You've done a lot of voir years.
Yeah.
I mean, we're honest with you.
I understand.
Yeah.
That's a chance we have to take.
Sure.
Judge, that's all I have.
Just a few questions, John. How long have you been county attorney?
15 and a half years now. We're halfway through this year. Yeah.
So you've obviously politicked a lot in Letcher County, know a lot of people in the community.
Yes, sir.
How long have you resided in Letcher County?
Other than the 8 years I was off to school, all of them.
Or even when you was at school, your mom and dad lived there,
That's
families from.
Wow. So yeah, this dude, other than the 8 years he was away in college and then law school, I wonder if he took a victory lap in college. Wow. So this dude's a homer. Homer AF. Born and raised. He don't sound like it, though. He didn't sound like it.
From Letcher County?
Yes.
Have roots going back to Letcher County, all over Letcher County, don't you?
Yes, indeed.
And again, is there people in your community that you, how many, as a county attorney, I don't even want to battle, how many people you talk to in a week?
I don't know.
I would say, you mean just in my work?
Just in general, yeah, not counting family, but just people walk on the street, people calling the office, people wanting to visit your office.
Probably 100 or more weekly, sure.
And you have a private practice also, don't you?
Yes.
And so you do car wrecks and other litigation, other than just criminal prosecution. So you have clients, not just from the criminal world, not just officers coming in, you have other clients coming in for wills and mistakes and all that, which probates.
Yes, that's true.
How often does conversation turn to this case?
Well, for the first probably year after it happened, pretty much the first time I'd see someone, talk to them, they want to talk about that.
Well, because you're the county attorney.
Sure, yeah. And then whenever I'm in court anywhere else in the Commonwealth, that's the first thing. Oh, you're from Letcher County. They want to talk about this case. So, yeah.
So it comes up frequently.
Yes.
Not as much today, I guess, as it did the first year you said. In those conversations, just talking about the people of Letcher County, not in other counties, we're talking about attorneys, because they're always included there. When you're talking to just people in Letcher County at ball games or cookouts or fire department raffles, whatever, how often does this still come up?
Really, every time a hearing or something like this comes before the court, it pops right back up to the conversation of the day, and then it'll fade into the background and come back.
When that next article comes up,
That's it.
do you subscribe to and I put you on the spot, do you subscribe to the local newspaper?
Yes, I do.
And have you seen articles on this?
Oh, yeah, lots of them.
Do you also check their website, read articles on the website?
I used to more. Now that I've got the subscription, I just read in the paper for the most part.
Can you tell us, if you're familiar, what is the Speak Your Piece?
It is a sort of it's really cool, but it's a local opinion thing. Anyone, anywhere can call in and leave a message, and they'll post it in the newspaper. Yeah.
And then they're on the website.
We'll post it in the newspaper.
We publish it in the newspaper. It has a whole section.
You can call in anonymously,
Yes.
leave a voicemail, and publish it in the newspaper.
Correct.
That's based. Oh my God. Wait, you can just call up in Lonoke County and just leave a voicemail and just fucking drop some bars. And then the newspaper's like, all right, we're boop, 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 type, print. That's awesome. That is so cool. That is so cool. You could just Fed post in the local newspaper. They didn't get to do that where I grew up. But like you saw some pretty spicy letters to the editor about the city council or the mayor once in a while, or the school board. But holy cow, you could just leave anonymous email like letters to the editor. That's so based. That is so based. Yeah. It's a town-wide bulletin board system. Yeah. Yeah, Aphex, what's up, man? How you doing? Oh, let's go. Where are you at? I just saw you. Did you post in here? Somebody's saying they're adding you. Less than 10% of people have been out of North America. Yeah, but that's not like we literally have an entire continent. Like, you know, people not traveling out of America. Like the average American's traveled more than a lot of Europeans are, really traveling all over the U.S. So, can I use slurs? I don't know. Imagine chat trying to build a tower. That would be so funny. That would be so funny. Shredder says, "What up? How you doing, man? What's up?"
In regards to online, you can actually make comments to that. Can't you? Have you seen that? Are you aware of that?
No, I've never seen Speak Your Piece online.
Okay, fair enough. I want to ask you more on that. Jamie, in regards to the hundreds of thousands of people you've talked to in the community in the almost 2 years since it's come about, what do you think the percentages are of people that made their mind up or have very strong opinions one way or the other?
I couldn't say a percentage, Mr. Steele. It just seems like there's a very strong Team Mickey and there's a very strong Team Judge Mullins. You know, lots of people tend to fall on one team or the other.
And I think you said you'd have 20,000 people, get 14, it's going to fall in the middle.
Yeah.
Let me ask you, Jamie, in regards to you said Team Mickey and Team Judge Mullins, are they pretty rooted in their position?
Seem to be, you know, they really do. They seem to be from the start, from the outset. People started teaming up, it felt like. Yeah.
And as a county attorney and as a public defender, do you see changing venue as appropriate in this matter, based on your understanding, not only the people of Letcher County, but also of the rule of law?
Yes, that is my opinion. Just for judicial economy, for one thing, we can bring the circus back to town and try and do this, and just you'll just end up having to go to another venue eventually. However many times you want to set it for trial in Letcher County, you know, it just doesn't seem feasible.
And you've been through the 4-hour process, speaking jury multiple times in Letcher County, haven't you?
Yes, I have.
That's all I have.
All right. Can you call?
Just a quick follow-up.
Sure.
Mr. Hackney, I heard that you had been Lonoke County attorney for 15 years, been a public defender.
Yes.
How many times did you file for a change of venue?
Never.
Never. So you didn't have any high-profile cases or any cases you ever worried about?
Nothing like this.
All right. And how many times have you ever seen that the Commonwealth filed for a change of venue?
First time I've seen it.
And I think you said whenever you go out of the county, especially, people ask you, and when they find out you're from Letcher.
Yeah.
Is that because you're with the county attorney's office or just, I'm a citizen of Letcher County?
I don't know.
Don't know.
You'd have to ask them.
Okay, I got it. And can you see, no matter what, I know you said that this could be a terrible situation, but did you ever know of any cases that were real high profile that they tried them right there in that county that it happened? No matter how high profile.
I would imagine it's a high profile case.
Kyle Rittenhouse, the January 6th people. I mean, pick and fucking choose. We have so many of them that get tried no matter what. Almost all of them.
History of our county.
Yes, but I'm just saying.
OJ was tried in LA County, although they had to change courthouses because one of them was damaged from the earthquake. But OJ was still tried in LA.
High profile cases. Did you ever hear of that case in Pulaski County where the sheriff got assassinated?
No.
Okay.
We're trying. Okay.
That's all. That's all.
All right. Thank you, sir. You're released from your speech.
Yeah, valid. Thank you.
Judge, if you'll permit me, I'd like to call out the name because one more person to make sure they're not here, and that would be Mr. Matthew Butler.
Is Matthew Butler in the courtroom?
Could we approach the bench on that?
Okay, so they're going to approach the bench on some stuff here, guys. We're going to...
For a few minutes.
So they're hanging out. They're just limping along. Let's see if we can find when they come back. Oh, they go right to the...
And if the...
Okay. Oh, okay. So we're... All right, here we go.
All right, counsel, you can approach and question from now. All right, sir, if you will, please state your name for the record.
Matt Butler.
All right, Mr. Butler,
So they have this guy available by phone.
your first going to be question on counsel on behalf of Mr. Stines. Go ahead.
Mr. Butler, would you state your full name?
Matt Butler.
And what position do you hold in Letcher County? I'm sorry?
Go ahead with the question.
I just want to ask, what position do you hold in Letcher County?
I'm the Commonwealth Attorney.
And how long have you been Commonwealth Attorney?
What the hell happened here? Hold on, chat. Hold on, chat. Hold on. What the heck just happened? Can you guys still see it? Dang it. What the? Hold on. That was weird. There we go. So this guy is a Commonwealth attorney. So it's another prosecutor involved.
I just want to ask, what position do you hold in Letcher County?
I'm the Commonwealth Attorney.
And how long have you been Commonwealth Attorney?
July 1st, 2024.
Mr. Butler, I guess I got to ask you, you know, we tried pretty hard.
We don't need to discuss
All
this.
right.
Can you ask your question?
Okay. Let me ask you, you signed an affidavit. Who asked you to sign an affidavit for a change of venue?
I believe that was the Commonwealth.
Okay. And how many changes of venue as you as a prosecutor have you asked for?
None.
So you don't have, as you sit here today, you don't have any issue with the, I guess, fairness or the ability to trust the Letcher County juries, do you?
I don't understand the question.
Well, do you have, as you sit here today, do you have any trouble in relying on the truthfulness and the fairness of the Letcher County jurors?
The question of whether or not Mr. Stines can receive a fair trial and whether the Commonwealth can have a fair trial is based specifically on that case. It was a case-by-case approach. If there were a case where the defendant could not have a fair trial and the defense wanted to move it, I would not object to that. If the Commonwealth could not receive a fair trial in a case, I would move to change venue on behalf of the Commonwealth. But it's a case-by-case approach. This case is unlike any other that has happened, to my knowledge, ever in my circuit court, but certainly found up in a Commonwealth attorney.
All right. Can you tell me what exactly is a fair trial for the Commonwealth?
A fair trial for the Commonwealth would be one where the Commonwealth feels like they have just as much of a shot of getting an unbiased jury as the defense does.
Okay. And if the jurors could say that they could follow the judge's instructions and follow.
Absolute nonsense. Absolute nonsense again. You are not entitled to a fair jury. You are not entitled to a fair jury. You're not entitled to a fair trial. You're not entitled to due process as the state. You are not entitled to any of that. Once again.
Follow the law, would there be any problem with that jury?
You're asking about whether or not that can happen at the time you're picking a jury in Letcher County. And my affidavit supports my opinion that you couldn't even get to that place, that there is no way to get a jury in Letcher County, Kentucky on this matter.
Is that based on your personal talking with people or just on like the coverage?
I live in Letcher County, and I've seen these concerted efforts like you, your investigator, and others to change the jury pool, and I feel that it is extremely unfair that you have taken.
Oh, this is a guy grinding an axe now. I know what you people are doing. Listen to this man cope and seethe. Listen to this attorney. This prosecutor's coping and seething right now. Wow, chat. Whoa. Listen to this. Listen to this man get indignant.
Supports my opinion that you couldn't even get to that place, that there is no way to get a jury in Letcher County, Kentucky on this matter.
Is that based on your personal talking with people or just on like the coverage?
I live in Letcher County, and I've seen these concerted efforts like you, your investigator, and others to change the jury pool, and I feel that it is extremely unfair that you have taken great steps to imply that there's some sort of conspiracy that there's not, and the Letcher County jury could not see this matter. Also, the victim, the murder victim, wasn't elected official, and the sheriff wasn't elected official.
Okay. Now, let me ask you something. You didn't, Mr. Steele is the prosecutor in this case. Did you just voluntarily withdraw to get off this case?
Within about an hour of finding out that your client had killed our district judge, I had spoken with the Attorney General's office, and they had reached the same obvious conclusion that I was, that it would be better for a prosecutor from outside Lonoke County to sit in this matter.
So, guys, this is the actual Commonwealth. The actual attorney would have been involved in the prosecuting. The county attorney does not sound like he would be involved in that. But this guy's very uppity. He's very upset.
All right.
Sure.
Hi,
1
Dave.
second, please, sir.
Yes, he's mad that tricks have been used against him. The tables have been turned.
Mr. Butler, I'm back. Were you ever related to Mr. Mullins?
At one point in time, from December of 2014 until July of 2029, he and I were married to a pair of sisters. During that period of time, I did not practice in Lonoke County.
Okay. All right. Thank you.
Understood.
Oh, he's kin. He's kin to this man. Oh, he's kin to the victim. That's brilliant.
No questions, Your Honor.
All right, Mr. Butler, thank you for your cooperation.
They don't even ask him a question. They just let him go.
Thank you, Judge Butler.
All right, any other witnesses?
No, Your Honor.
All right. Anything else on behalf of the Commonwealth?
Nothing better for office this year.
All right. Any argument, counsel?
Judge, if I could read from the case, the mere fact that jurors may have heard, talked, or read about a case is not sufficient to sustain a motion to change opinion. Absent of showing that the counsel descriptions of the investigation of judicial procedure have prejudiced the defendant. That comes from the case Commonwealth versus Ronnie Lee Bowling out of the Law Circuit Court. It's cited at 942 Southwest 2nd 293. And the reason I'm citing that case, Judge, I was the attorney in that case. Very serious case. And at that time,
Oh, and those are the worst ones. I mean, those are the best. That's some of the most dangerous ammo you have in your pocket. It's like, Judge, it's a case that's presidential, and I know it because I lived it.
that was back, of course, this decision wasn't done until 1997, and the actual offense itself didn't occur until it was much earlier, sort of earlier. And
Think about it, chat. 1997 was 30 years ago. Almost. Fuck, I'm getting old.
London was a small town, pretty small town by then. It's grown some now. And I remember there was a lot of coverage. There was all kinds of talk, everything else. It was too raw.
And remember, chat, yeah, changing venue is in the Mickey Stein's favor, so. Yep.
Two murders. And I moved for a change of venue for the defendant. And it wasn't granted. And believe me, there was a lot of talk. And yet we tried to get a jury, and they did. They got a jury in that case over my objection, but they did. They did grant the change of venue. And I would just ask the court maybe to look at that case, because when I asked for a change of venue, I was pretty much told that those things didn't matter much about reading about them, hearing about them, talking about them. And I think that's kind of the position they're in Letcher County. Now, I don't know why people are so concerned that maybe the Letcher County people couldn't be honest and fair, because they elected Mr. Stein. He put his trust in them, and they put their trust in him. And I think there's some position here where he should have the right to be tried in his own home county, where he feels comfortable and safe, and that he is around the people he knows. And again, I think from hearing from them, if it's that kind of a wide coverage, that was some kind of, there's so much to talk about. Where could you go, and where would you feel more comfortable? I know for his witnesses, at least it would be more convenient to be closer to home there. It would be easier for them to come to court. Now, as far as these cases being high profile, I lived in Pulaski County. Several years ago, we had a sheriff that was assassinated. The trial of that person occurred right there in Pulaski County. And that was high coverage because he was assassinated. I just don't think that at this point in time, until we try to get a jury, and I think that's been the result of most of the cases that I've seen, that unless you try, you have to try. And then if you can't, then it's probably more pertinent to do it at that time. But at this juncture, I don't think that's been enough. Just having three people that are they're related either by blood or they were at one time. Mr. Butler was talking about that. But to have people that are working in the courthouse, one of them was a witness, and Mr. Haddon, I think he's the county attorney. I think that's kind of telling. And I also think that the people that testified at least have never had a situation with the Commonwealth ask for a change of venue. Now I know this case may be unusual, but unusual isn't the case. And I would just ask the court to consider all of that and not change that.
That is brilliant. Unusual is not the test.
Time until we've at least tried to get a jury.
All right. Response, Mr.
Yes, Your Honor. Let me just say, Mr. Cox, I remember those cases. When I say this, I'm not poking, but Mr. Bowman was in 1989, killing a gas station. Mr. Catron was in the early 90s. I think mid-90s was when Mr. Catron. Just me and Mr. Cox spoke on that was before the famous internet and the coverage of which we see today from bloggers and YouTube, whatever. It is a much different reality of what we're dealing with today. I'd like to point out one of the things that's always struck me since we first got this case is that one of the admonishments the judge gives a juror during the qualification is do not go by the scene of the crime and do your own investigation. This would require us to have a trial in the building of the crime. The video footage that we would show from the outside of the response to Mr. Stines leading is of the building where they're going to walk in and out of every single day during this trial. So it's impractical.
Make them wear blindfolds. I don't know. That's not our fucking problem. That's yours.
One, that they could not do that and not go by and look at the scene of the crime. The fact that these are both elected officials also
He's calling me out. He can call out these nuts.
against their argument that it should be moved, Judge. And Mr. Hatton, who's ran for county attorney many times, almost 16 years in, he said it's very team Stines or team Judge. It's just drawn a line in the community that we do not have a reasonable chance of getting a jury pool out of Letcher County. I believe when the numbers come back in Letcher County, their population is going to be less than 20,000 people because of the flood they had there a few years ago. I believe the number was, and Mr. Hatton said in the mid-20s, but I believe the number will come back less than 20,000 in the next census. So, and they're losing population every day. I think he stated very clearly we get full 20,000 people just to possibly do 14 on the jury pool. This is from the county attorney who deals in these, and I can't imagine the phone call the county attorney gets where he's not going to that job. Is the amount of phone calls they're going to have to get in a day just from citizens on a daily basis. The case of Brewster, 568 Southwest 2nd 235, and interpret Shepherd is requiring a change of venue when there's been prejudicial news coverage. It's undeniable. I think parties talked about the inaccuracy of some of these news reportings that are detrimental. These obviously news occurred prior to trial, which that's why we're here today and not at trial. And the effectiveness of news coverage is reasonably likely to prevent a fair trial. And I believe every witness that we had at that Wisconsin just couldn't get anybody that would sit and actually give a fair trial this night. So a couple of things that the elements for the change of venue has been met, and we request such.
All right. Your response?
The only thing is I'd say as far as prejudicial news coverage or any kind of coverage is based on like that video that we talked about. And that's not the end of the story though. And I think I believe that with the trend has been like what I've seen in change of venue, you have to try. If in Pulaski County.
I don't think there's any police law that requires.
No, it doesn't, but I can say this because of the trend of what they're saying, how much coverage it gets and this talk and things like that. They sure got one in Pulaski. And that was an assassination of a sheriff.
And what year was that?
That was probably, and he may be right midnight. I can't remember exactly.
I think it was 94.
Well, I think it was pre.
94.
But the internet itself is such a big unknown, how many people are on it and where they're at, this, that, and the other. I mean, we could just go on and on, but where else in the world are we going to go? So that's what I would do.
Well, that'll be, if I do grant the petition, that'll be the court's decision. First of all, there's been a lot of questioning. I don't think anybody's trying to question the honesty or fairness of the people of Letcher County. This is a unique situation, to say the least. I am, at the request of defense counsel, going to review the case law that they brought up today and cited. But I can tell you the court is going to be hard pressed not to grant this petition for change of venue. I cannot fathom the thought of reasonably being able to obtain a jury in Letcher County with the amount of coverage. I do believe the county attorney said, and I've already kind of thought of that analogy. It seems very clear that you've got a very divisive situation where you have Team Stines and Team Mullins, and these are some irretractable positions that would make picking a jury in Letcher County all but impossible. But I'm going to withhold ruling. I'll issue a written ruling after reviewing the case law cited by the defense as well as the Commonwealth and get that ruling issued. Anything else we need to address today?
Yes, Your Honor.
Okay.
Your Honor, as to the second phase of that equation, Your Honor, of course, we would maintain our objections with your motion. But in the event the court grants the motion, Your Honor, then I believe the parties should have an opportunity to address. I think the statute talks about the preference being adjoining counties first within the circuit. And then, Your Honor, so I understand it's the court's decision, obviously, but I do believe that the statute would require that we do have input as to the locale and be able to present evidence to the proposed location. Your Honor.
Well, and if I do grant the petition for change of venue, we can, I'll allow filings and requests and anything you'll wish to be heard on a potential location.
Yes, Your Honor,
I don't think, but like I said, it's not going to head to an adjacent county. I mean, realistically, if the court does grant the petition, I think we're going to need to be far away enough where the direct media coverage is not as focused as it's been in this part of the state. So,
Your Honor, as to that second question, though, I mean, I understand, Your Honor, about legal analysis is accounting to which there is no objection, Your Honor, on the second part of the analysis.
right, but it also requires it to be the most convenient county in which a fair trial can be had. My review,
Yeah, it does
I
help.
participated in change of venue cases, and in my review of the law that's been promulgated by the Supreme Court, there is wide discretion vested within the circuit court on picking that file.
This judge, yeah, it literally is up to him. But all the reasons cited, it's almost impossible to get.
Destination. So
Yes, Your Honor.
we'll address that at the appropriate time. All right. Anything else today?
Looking for the call, John.
Mr. Bartley, anything else on behalf of Mr. Stines?
There you go.
All right, the court will issue written findings and rulings in regards to all the matters that are heard today. I am going to contact the parties by email to start looking at some scheduling timelines about and getting this matter set for a trial. I'll follow up with that, and then once the rulings are issued, we'll get a date set for any other additional outstanding matters. If there's nothing else to be heard, court will be in recess until the court orders for proceedings.
That's it, chat. So there we go. We're all caught up now with Mickey Stines. Oh man. This is getting interesting. This is getting interesting how this is all shaking out. And yeah, we kind of got bookends. We got a guy who's running for sheriff and probably will become sheriff, getting his case dismissed. And then we got another guy who is sheriff. And this case is like we're still in the thick of it now for Mickey Stines. So time will tell, chat. Time will tell. 2 years and he doesn't look any different the day he did it. Well, yeah, that's true. And I do like this judge kind of flags his leanings, yeah. Yeah, if the prosecutors bought it, it would get denied 100%. Yeah, if they could get, they did a good job preserving the issue here, and this is one of those times where you have to have the. This is one of those times where you need to have the hearing. So that was a very good hearing, very good work by his attorneys. He's got some top-notch attorneys. J-Ross says, how's Florida? Today was hot as ball sack outside. Oh my God. But it's worked. We're getting there. We're getting there. Carmelo Anthony's mugshot's been released. Well, there we go. Well, we'll take a look at it maybe at some point here. Guys, tomorrow night we got the third. Well, tomorrow's Thursday. We got Thursday night show. We'll be getting into that. And yeah, we'll kind of leave it at that. Yeah, the state's attorneys weren't looking too good. JC Adult says sitting in jail for 2 years without trial is criminal. His attorneys want this. They want to slow it down. They want him to get evaluated. Like they're trying to drag this out. This is something the defense wants. They need to slow everything down. So no, this is exactly where they want it. Oh, the guy who shot the Minnesota Senators pleading out tomorrow? Oh, I forgot about him. Do we have a Northern Ireland update? I think I don't know. I still think it's up in the air whether or not the Irish are really sticking to this or they're just chipping out. So we'll find out. We'll talk about that more tomorrow. So the judge he shot wasn't at Shoma? We don't really know. We don't really know yet. It sounds like Mickey Stines kind of freaked out, but we don't really know for sure. Stop rolling your R's. What about my R's? What R's am I rolling? Smoggy Buck says, come out, you black and tans, but literally. Yeah, except for the Republicans, the black and tans were the equivalent of a Klansman. So they would not, the Ulstermen are not going to be singing come out, you black and tans. So. Yeah. So with that said, guys, I will see you tomorrow. Hopefully I get this stuff fixed. The riots in Northern Ireland are also taking place in central Glasgow. Ooh, good. Based out there, chat. So with that, guys, I will see you tomorrow. Hopefully I can get all the rigs set up. I was really disappointed I couldn't get that for you guys, but hopefully by tomorrow. And guys, just remember until next time. Chat. Just because you did it does not mean you're guilty. And that includes Aaron Spencer. He is not guilty, even though he just bop, 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 bop to good old Micheal Fosler. And I hope Micheal Fosler is burning in hell for what he did to those children. So good night, chat. And I will talk to you guys later.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy